I would like to mention one.
Yes.
Inclusion in the list. Inclusion in the list must stay application.
New stay.
Yes. Yes.
Under compelling circumstances, I am mentioning one matter, my lord, for seeking your lordship's leave to file, my lord, without certified consent. This order was passed on 24th, 26th, applied, my lord, till date, my lord, 24th, my lord, February, my lord, the order was passed by the Honorable Justice, my lord, Joy Gupta. And
What is the urgency?
urgency is that, my lord, in that college, my lord, we want, I want to transfer, my lord, that college will be, my lord, that post will be, my lord, filled up, my lord. Pursuant to your lordship's direction.
Tell my brother. If my lord allows, then we will allow.
Urgency, we are not yet to understand. What is the urgency?
What happened, my lord, in this matter, my lord, I want transfer from Pakuahat Degree College, Malda to, my lord, Chatna Chandidas Mahavidyalaya. What happened, my lord, 500-kilometer distance, my lord, I am the lady teacher, my lord. I have, my lord, one only, my lord, daughter, my lord, she is nourishing before, my lord, in Pankura for my lord, parents. And, my lord, my husband is also, my lord, working at, my lord, Midnapur, my lord. That is, my lord, predicament pursuant to your lordship's direction.
Yes.
My lord, may I be permitted to mention this matter for inclusion in the list because today is the date was written in the presentation form. The returnable date was given today. My lord,
No, automatic আছে না?
And leave to mention an original side matter. This
Original side. Wait, adjustment. Yes.
Upon notice to the other side, my lord, I am mentioning one first appeal hearing, my lord. My lord, the response.
Hearing, give the slip, let us see. Come, my
Lordship restoration, lordship.
Where is your service upon other side?
Lordship, I have served the people.
Where is the notice?
Lordship.
Come with a notice. Yes.
Lord, I am serving upon notice, my lord, for paying for the upgradation, my lord. It is the item number 82, my lord.
82 was called on, sir. Entire list was called on. You did not respond. Wait for your turn.
Monthly list of milliard, 110 milliard I am paying. 110 milliard for
It
you.
was called on, sir. You were not there. Yes.
I also want upgradation in
Upgradation. All the matters were called.
Fix it milliard, any day milliard.
Sorry.
My lord,
Wait
may
for
I be
your turn.
permitted to mention a contempt application for inclusion, my lord?
Our order.
No, my lord.
Our order. Or some other judge's order.
Some other judges order.
Then why you are mentioning?
My lord, assigned matter.
Assigned matter.
Yes, my lord. My lord, the matter was.
How can it be assigned?
My lord, the matter was running in the list, monthly list of February, but it did not.
Yes, we have kept it apart. You have given notice. Where is your notice to the other side? Give a notice to your other side and mention. Non-contempt.
My lord, kind leave to mention a matter for inclusion. It's a contempt application.
Our court
Yes,
order.
my lord.
Newly filed.
Newly filed.
Chalo niye no. Yes. Yes, Mr.
original side matter was specially assigned. My Lord Justice Urijit Banerjee and Justice Kaushik Chandu differed on a point of law. Now it's been assigned to your lordships. Lord, the issue is short whether an authority has the right to forfeit when I have failed to deposit the earnest money. Right of forfeiture of
Surfacey.
Right of Kolkata Municipal Corporation to forfeit the money where I have not deposited the amount. Whether tender was extended, that's an incidental issue. The legal issue is just this right of forfeiture.
So there is no special urgency, Mr. Banerjee. Please hand over the slip. We shall, as we sit in the original side, we will take care.
Very well.
You know.
But if your lordships, then I'll put them on notice that I mentioned the matter and then.
Then you put them on notice and mention.
Or could I just give this and I'll put them on notice? Whenever your lordship sits, accordingly I'll indicate in that notice.
We usually do not allow any নিয়ে রাখো তারপর দেখো. Yes,
my lord, may I permit to mention item number 27.
কিসের জন্য?
My lord, this matter was only fixed for hearing was concluded Only that Puri matter.
Could be taken up. then.
PM. Now, my lord, we are. Now, my lord, we are.
Was it Pathad?
Not part of that is otherwise I will not disturb your lordship. It was hearing almost completed only for the purpose of that affidavit file. And we have also disclosed our stance over the case is
Is your other side?
Mr. Shushovan Sengupta. Now, my lord, we are something, my lord, might something happen in the next week or not. We do not know. That is serious.
সায়েন্স এই কার্তিক এই ফরওয়ার্ডার্স এর গ্রুপটা একটু উপরে
Leave of Justice Chatterjee.
wait yes
Your lordship, I like to mention a matter for upgradation in the daily list. The matter,
you cannot because it was called, you were not there.
your lordship, it has been running under item number 96.
Yes, it was called on. It was called on, sir.
Your lordship, the notice has been served to the opposite party also.
What can be done, sir? We called on, you did not appear. You will wait for your turn. Yes,
My lord, with kind leave of Justice Chatterjee, my lord, may I be permitted to mention one matter, my lord, presided by your lordship and Justice Mantha, that OBC matter, my lord. It is fixed on Wednesday, my lord. We have taken out a contempt application new, my lord. I will give your lordship's officer, my lord, the number. It can
it
be
is original side or appellate?
original side, my lord. I will give the number to your lordship's officer, my lord, so that it can be listed on Wednesday.
নিয়ে
Grateful, my lord, deeply.
নাম্বারটা দিলে ওই যেদিনকে আছে সেদিনকে লিস্টে রেখে দিই। Yes, call the
Deeply
list.
My lord, on behalf of respondent number 3 to 5, Mr. Amol Kumar Sen is appearing, your lordship. He is engaged before other court, your lordship. I'm praying for a day's adjournment, your lordship, kindly.
File and you have filed the exception.
No,
My lord,
it is filed by me.
You have filed it.
Yes. I served the copy on last August. It was prepared, not copy, not served, was copy served.
That's
I have served on 5th March.
yes. They are not today করে রাখুন।
grateful,
Come tomorrow.
grateful to your lordship.
এই ওকে ওই কপি দুটো ফেরত দিয়ে দিচ্ছি।
I'm grateful.
কালকে আবার আসতে বললো, কালকে বললো না?
File it tomorrow.
Fine.
Yes, next.
For the state respondent, ma'am.
My lord, item number 4, my lord, I beg to appear on behalf of the petitioner. So item number 4, I am appearing on behalf of the respondent number 6 and 7. So yesterday night I have received the instruction. I need some instruction from the. Nothing is there. Simple and innocuous prayer, expeditious hearing of an original application pending before the learned tribunal. My lord, my age is 81 year. I have several age-old related medical complications. Only simple and innocuous prayer. The impugned proceeding which was pending before the court of West Bengal Land Reforms Tenancy Tribunal could be expedited.
As per your pair, the matter was adjourned.
No, new motion.
Read the order. Read the order which you have come with.
My lord, that is there, my lord.
Read the order.
My lord, that is there. That is there.
This was on 20th of February and you have filed it on 27th February.
No. 20th February 2024.
When was the what happened on 19th July?
My lord, 19th July, my lord, they, my lord, took an adjournment before the.
Where is the order?
My lord, that order is not. Several orders are there, my lord.
last for the 19th July.
What happened on 19th July?
Both the
I don't have
parties,
any
my lord,
instruction, lordship.
took adjournment. Both the parties took adjournment.
Then why should we interfere?
My lord,
Basically, keep it, lordship.
my lord, only thing is this, my lord,
You withdraw, we will give you leave to file an application for preponement before the tribunal.
My lord,
My lordship,
several
next-
occasions, my lord,
next date is on
we
13
submitted
March 2025.
before the honorable.
My lordship, next date is on 13 March 2025.
13th March.
Sorry,
March
yeah,
2025.
13 March 2025 is the date.
Next date. You don't know your.
My lordship, it's there in page 9,
Para 16.
para 16.
Yes, my lord. That is absolutely.
Huh?
13th March is the next day. 13 March
You
2025.
didn't know him.
My lord.
You came to know land just.
My lord,
just now.
that is an admitted, but averted in my application.
About it.
Yes, my lord. Averted.
For this averment. That you stated anywhere. That the
My lord,
next date- next date-
page 9, para 16. My lord, only prayer, my lord, very innocuous prayer.
No, this cannot be a matter of course.
My lord, senior citizen,
cannot be a
81 year old.
No,
my lord.
that is because you are engaged today. You have nothing else to submit. Repeatedly, you took adjournment before the trial.
No, not repeated.
So
One or two
24th
occasions at that.
24th order
And
itself
that
shows,
too, my lord,
try to understand 20th August, 20th February shows that you
My-
prayed for
my
adjournment.
lord, only humble,
19th July matter was at.
only humble submission before your lordship is this, my lord, the learned tribunal, they are not interested to take the hearing matters at all, my lord.
Then let them fix a date, then come to us. 13th March, why should we interfere?
My lord, then adjourn till 13 months thereafter.
No, you withdraw the petition.
My lord,
Go and appear before the tribunal on 13. Otherwise, you will again pray for adjournment that I have gone up to High Court. These tactics should not be adopted. You
My
should
lord.
accordingly advise your client. While accepting the brief, you should tell the client that please do not ask me to go forward with this because it will be dismissed.
my lord, my lord, my lord,
Hasta-
my lord,
Are you withdrawing or we dismiss?
my lord, I
There
have
is
to-
no other
this is
option.
not my brief, my lord, I was engaged.
Ah,
That is
now
why,
you
my
see, whatever you have been told, you are vomiting before us.
my lord.
You have not.
My lord, my humble submission before you, kindly consider, my lord, the age and associated medical complications, kindly, my lord.
In course of hearing, we have been informed that the
most of it.
Lord, item number 5, my lord, I'm for the appellate. My lord, last few occasions, my lord, the respondent, my lord, praying for time for filing affidavit.
Who is appearing?
My lord, Mr. Mukarram Hossain is appearing for the bank, my lord.
Key matter ছিল?
Even, my lord, last 2 days, without, my lord, any recording, any order, my lord, this matter adjourned twice.
Now they have filed the opposition.
No.
What order are you challenging?
Lord, here I have challenged, my lord, in the writ petition, my lord, I prayed that the petitioners are the, my lord, ex-employee of, my lord, rural bank. My lord, initially, my lord, they are not getting pension. My lord, a writ petition was moved before the, my lord, Honorable Karnataka High Court, which was allowed and directed that the ex-employee of the RR banks will get, my lord, the pension at per the, my lord, a sponsored bank. My lord, because there is a, in every RR bank, behind there is a, my lord, bank, sponsored bank, my lord. Now, my lord, that went up to Supreme Court. Supreme Court upheld the decision. And we, my lord, filed this writ petition with a direction upon the authority concerned to fix the, my lord, pension at per the sponsored bank. Accordingly, my lord, the concerned bank, my lord,
Sir Rahman, it needs to be heard out finally.
my
There
lord,
is no scope for interim order.
my lord, interim order, my lord, here, my lord, I am coming, my lord.
Whether bank called you to deposit the,
Well, I'm coming,
your
in-
proportion of contribution or anything like that?
My lord, I only, my lord, 2 minutes, give me time, my lord, I will, my lord, to sort out that, my lord, place the case, my lord. My lord, in the meantime, my lord, in a contempt petition, my lord, the central government, in connection with the order passed by the Honorable Supreme Court, my lord, central government, my lord, accepted the proposal that yes, they are entitled to get pension at per the employees of the sponsored bank. So, my lord, that part is now over. The second part is, my lord, initially we are getting pension as per the regulation framed by the concerned bank from 1/4/2018. My lord, my lord, we are entitled to get pension from 1/4/2018 before, my lord, the order of the Honorable Supreme Court. My lord. Now, my lord, we applied for commutation February 2019.
So when did you retire?
My lord, retired, my lord, before, my lord, 2014. There are 18 petitioners, my lord.
Very good.
My
Now,
lord.
are you getting pension?
My lord, I am getting pension, but 1/3,
The regulation of the bank.
my lord. My lord, I am coming, my lord. The commutation applied for February 2019 and the amount credited, my lord, September 2019. Now the authority concerned paid pension from 1/4/2018, but the commutation amount deducted from 1/4/18 instead of September 2019.
What is September 2019?
Because this is the amount credited, the commutation amount credited to our account.
When?
September 2019. So, my lord, they cannot, my lord, deduct the amount from my pension from Act 1/4/2018. My lord, may I, my lord, I am coming. I am coming.
No, commutation will be on the calculated on the basis of your final pension.
My lord.
So final pension as percentage of commutation, you submitted a declaration.
My lord.
It has been commuted and delivered to your account.
Delivered to my account.
In
So, my lord,
September 2019.
in, my lord, now the commutation amount, the bank will deduct, my lord, month by month from my pension. They are deducting from 1/4/2018 instead of September 2019.
So very good. That period of deduction which was made.
One third amount, the amount which we have not got, we are paying, including interest.
Including
Interest. Prior B of my writ petition, page 37 of the stay application.
So the amount deposited from 1/4/2018 to September, you are now trying to refund back
Mile,
along with interest.
along with interest. And so far the fixation of pension, that has already been central government accepted, and
Final value of pension. 2018 থেকে register করছে, pensioner সেটাও পেয়েছে। এখন commute করতে ওকে দিয়েছে treating the date to be September 25. But what is the wrong?
না, বলছে 18 থেকে।
Where is the what, sir? You should have said that in your petition, in the stay petition.
in my stay petition as well as writ
Mr.
petition.
Raman, to substantiate your claim,
My lord,
you have to show us that there had been deduction from 2018.
My-
Suppose today I make an application for commutation to my employer.
My lord.
I'm a retired employee.
my lord,
I say that yes, I'm getting regular pension.
My lord.
You commute this portion of my pension with effect from such and such date.
my lord. But
The contention is,
Yeah.
though the commutation was given in 2019,
my lord,
but they have deducted the money from the date of my entitlement to pension.
my lord,
This is your,
my
this
lord,
is your,
my lord,
so
my
you
lord.
show us that
My
there
lord,
was
then my lord,
deduction of commutation.
I have to bring all the
No, what
passbook,
did
my
the
lord.
learned single judge say?
Learned single judge, my lord, nothing said about this.
And that is a very general statement you make. It is a 40 pages judgment.
My lord,
You are not being able to show us that portion where records that your deduction is from 2018. Show us one line from the judgment.
my lord, there is no, my lord, it has not been mentioned, my lord, though in my writ
This
petition
way the
and my,
matter cannot proceed,
my,
Mr.
my
Raman.
lord,
You are wanting stay of an order of dismissal. There cannot be stay of a dismissal. Appeal has to be heard.
my
If
lord.
you are entitled, if there has been illegal deduction, you will get it back with your interest. So what is the use of keeping the matter pending? There is no scope for interim order. We will
My
delay
lord,
filing
I
of
am
the
not,
purpose.
I am not praying any interim order, but I am praying only, my lord, let the matter be heard out because, my lord, we are, my lord, more than 70 years old, my lord. A date may kindly be fixed, my lord, instead of repeated, my lord, your losses
Has to be
order.
finally heard, Mr. Raman. This cannot be on stay application hearing.
My lord, I understand, my lord. I am only praying, my lord, a date may kindly, short date may kindly be fixed.
No,
my
no,
lord.
we have to extend the time. Then you will file your reply. Then there will be paper.
My lord, they are, my lord, they have,
Petition was decided on affidavits. Writ petition in affidavit was preferred.
my lord,
You have annexed that here.
writ petition, my lord, affidavit, my lord, I have not annexed, my lord.
তা শুনবো কি করে বলুন?
So, my lord,
রোজ ঝামেলা। তারপর পেপার বুক করতে হবে। এভিডেভিট দুটো রেকর্ডে নিয়ে ওকে পেপার বুক দিয়ে দিতে হবে। তো ও তো এখন এভিডেভিট ফাইল করে।
এই যে 18 থেকে কেটেছিল আপনি এটা
কি গল্প করেছে আমরা সিকিউরিটি। মোকারাম।
my lord, I do not know, my lord. He is not appearing, my lord. Last two occasions,
This
my lord,
is
junior, Saint Juniors, my lord, praying time before your lordship, my lord.
It will be next Monday. You
My
give a notice to Mokaram.
my lord.
You tell him that matter appeared, none appeared. You it a Monday রেখে দাও, next Monday. ঠিক আছে। Date you have to produce that your pension
My lord.
computation has been
My
deducted.
lord, my lord.
Since 1st April 2018.
My lord, I understand.
Any document is to be
My lord, my lord.
shown. That from that date
My lord.
it was
My
deducted.
lord is absolutely right.
Next Tuesday করে দাও, next Tuesday.
Next Tuesday 18.
18 তারিখ অনেক ম্যাটার রেখে রাখা আছে না? ঠিক আছে। কিন্তু সিঙ্গেল বেঞ্চ পেয়ে যাবে এবার বাবা।
May I please, Your Lordship, I am for the appellant.
My lord, I am for
Item number 6.
My Lord, may I please, Your Lordship, I am for the appellant, my Lord. In this
my
matter,
I am for the respondent, my lord. My lord, I am praying not this week, my lord.
Why?
My lord, because my lord, I have already drafted the affidavit in opposition. I was supposed to file an affidavit in opposition today, my lord. It was drafted and it was vetted by the ministry also. But unfortunately, the officer is supposed to sign the affidavit, my lord, because of his personal reasons. Most probably, somebody died in his family.
You give him copy, he has to use a reply.
my Lord,
Yes, my
not
lord,
yet
my lord.
affirmed.
It is not yet affirmed, my lord.
To affirm in the meantime, give a copy to
Yes, my lord, we will give my lord.
after 2 weeks.
Grateful, my lord.
Much obliged, man.
Much.
Much obliged, man.
Item number 7.
My lord, I am appearing for the appellate, my lord.
আমি ওইটা দেখেছি।
না, আজকে তুমি
ওইটা হয়ে যাবে।
This record has millet come from Lojima millet. One of the respondents in the millet read millet, he passed away millet. He is aggrieved by the millet, impugned judgment millet. So his wife has been millet impleaded in the appeal millet.
Yeah, just.
ওইখানে পিটিশনার থেকে ওপরে ট্রান্সপোজিশন হয়ে রেসপন্ডেন্ট হয়ে গিয়েছিল।
Where is the 24th January order?
24th January order millet, page 21. Millet, start from page 13 millet. The 24th January order millet of Lojima millet. May I hand up millet?
Who filed the appeal?
Millet, appeal was filed millet. May I tell your lordship the backdrop millet? Initially millet, 9 millet writ petitioners filed a writ millet. That was millet. Order was passed by Honorable Justice Hiranmay Bhattacharya, directing the Managing Director of the West Bengal Transport Corporation millet to consider. Millet, he rejected the prayers. Prayer was millet from switching off from to millet from CPF to millet pension scheme millet. Against that millet, a writ petition, fresh writ petition was millet filed. 6 writ petitioners millet joined. In the first instance itself, millet, the respondents millet raised this dispute that since these 6 persons were not party to the earlier writ petition, so they cannot be made party in this next writ petition, because millet aggrieved persons were only millet 9 persons in the writ petition, because their petition was millet rejected by the Managing Director millet. The Honorable Justice millet Lopita Banerjee millet, she passed an order millet allowing them to be transposed as these 6 persons to be transposed as respondents millet. Now subsequently millet, all these 15 persons were parties millet. It was millet dismissed. The petition was dismissed on 4th of December 2024 millet, against which millet we have come. During the pendency of the writ petition millet, it was dismissed on 4th of December 2024 millet. On 16th of November millet, Shubh Chandra Jha, who was millet initially petitioner number 10 and transposed respondent number 7 millet, he passed away. It was not
When?
16th of November 2024.
That is prior to dismissal.
My lord, it was not brought to the notice of the Honorable Court millet. Be that as it may millet, the writ petition was millet dismissed. Now in this appeal millet, the wife, since it is a pension claim millet, the wife of that Shubh Chandra Jha, deceased millet, was arrayed as one of the appellants millet. So therefore millet, what happened is this.
How many years were included?
Yes millet, only 1 year, since it is pension claim millet. Other all sons are millet of millet majority major millet. So wife has got claim millet. So he was made a party as appellant millet. So therefore, this appellant Kuvela Jha, she was not party to this millet writ petition, and Shubh Chandra Jha, his name figured in the millet.
Preferred a leave to appeal.
Yes, millet, leave to appeal millet. So I millet took out millet application, can 2 application millet. Though millet kindly comes to the prayer millet.
Can 2.
Can 2 millet.
So the problem is only with Shiv.
Yes, millet. Shubh Chandra Jha.
And others are already
Yes,
alive.
millet. Other
Remaining 4
yes,
are-
millet. Yes.
So where is your can 2?
Can 2 millet, I have filed millet.
Which paragraph you have stated? Time?
Millet, paragraph starts from 12 millet. 12.
Each petition was dismissed by Justice Hiranmay Bhattacharya.
My lord. 12, 13, 14 and 15.
Just, no, that we can allow. You are for whom, madam?
My lord, I am for the respondent number 2 to 5.
2 to 5. So there is no scope for interim order?
No, 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 no.
Was the writ petition decided on affidavits?
Yes.
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 So file your paperwork. We will dispose of your application
lord.
for approval.
Similar issue is pending before your lordship. Mr. Amjad Ali is appearing in another. Very well, my lord.
My lord, may I only make one submission? My lord, I have an objection to this leave to appeal.
Why?
My lord, because my lord, the original writ petition was filed, as my learned senior had already indicated. The original writ petition had been filed by 9 petitioners.
9.
Now, my lord, the order in that writ petition was to consider their representation. Their representation was considered by the managing director.
This argument was considered by Justice Lopita Banerjee. That is why transposition was allowed.
Yes, that is why transposition was allowed, that no claim can be made by these writ petitioners who were added subsequently. 6 more writ petitioners.
Show us that order.
My
Lord,
lord,
that is, I have, my lord, annexed page 13 of Can 2, my lord. It starts from page 18 of Can 2, my lord.
18th of October 23.
My lord, by Honorable Justice Lopita Banerjee.
Directs the petitioners.
This bar was not
They
there.
were included as party
respondents,
Yes.
not petitioners. So now they cannot claim as an appellant. If they had been aggrieved by this order, they should have challenged this order to be included as petitioners. They could not have been included as petitioners because the impugned order was the order of the MD, which has been passed only in as against 9 writ petitioners, the original 9 writ petitioners. Now that order was not passed in rem; it was passed in personam as against those 9 writ petitioners. That order cannot be challenged by anybody else other than these 9 writ petitioners. So these 6 added persons were transposed as respondents because they could not have any claim against those orders. Those orders were not passed against them. So my lord, if at all this person concerned, my lord, the applicant in Can 2 concerned was aggrieved by this order, they should have preferred an appeal and should have been included as petitioners. This was not included.
No, when you filed this appeal,
My lord.
did you keep those 9 persons who were subsequently transposed?
6 persons.
6
yes.
persons.
Yes.
You implemented them as respondents in the appeal?
Yes.
They are petitioners. They are appellants.
My lord, kindly comes to me, lord. The memo of appeal once, my lord. Memo of appeal. How the cost title I have set, my lord.
No, you have included them as appellants.
Appellants.
They are
Appellants. Yes, my lord. I. Appellants, writ respondents number 6, 7, 8, 9, 10 and 11, my lord. That I have mentioned. Appellants, oblique, writ respondents number 6, 7, 8, 9, 10 and 11, my lord. Here, my lord, I am aggrieved by the honorable order passed by Honorable Justice Hiranmay Bhattacharya, my lord. Not MD. We are all aggrieved.
Now, whether the order or decision regarding the payment of pensions will adversely affect them or
Yes.
My lord, they will be affected adversely, definitely. But they were respondents therein.
since there is a possibility of their being prejudiced by any order which may be passed in this matter, so they should be given a opportunity to participate in the process.
My lord.
My lord, subject to correction, my lord, they should
No
be.
person should be punished unheard.
My lord, subject to correction. No, I agree. The principle of law is no person should be punished unheard. Yes, but my lord, the remedy is not the appeal. The remedy is probably another writ petition. But my lord, that also, I suppose, my lord, in my humble understanding, has been exhausted by these respondents, the transposed respondents, as well as many others, my lord, who had been added as parties, who had applied in the form of applications to be added as parties. That was also rejected by Justice Bhattacharya and even by Justice Banerjee, because they could not have preferred the writ petition against an order which was not passed against them, against an order which was not affecting them. The writ petition that was heard by Justice Hiranmay Bhattacharjee was, my lord, adjudicating the correctness of the order of the MD.
In that, while it was being heard,
Yes.
this point was stated.
Yes, 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 yes. My lord, first it was heard by Justice Banerjee, then it was heard by Justice Mantha, and thereafter Justice Bhattacharjee
State that they cannot be granted any relief here.
Yes,
No,
yes,
no, that perhaps that is not there. Please see the impugned judgment, memo of appeal.
Justice Bhattacharya even clarified the same with me,
At
my
the
lord,
end of
because
the
I
day,
was
my lord,
appearing in
kindly considers one thing. Even if
No, wait, sir. You have created the problem.
Actually, how many percent prefer the writ petition number 12697 of 2000?
9%, my lord.
9% file WPA. What was the cause which prompted them to file this writ petition?
My lord, they were challenging the inaction of the managing director of not considering their representation. Their representation was that they prayed for
Exercise our option for getting pension.
for getting pension. Yes.
The managing director concerned rejected their prayer.
Yes, rejected their prayer.
Challenging the said rejection order, this writ petition was filed. WPA
22388.
2023.
My lord.
In this writ petition, 6 other was added as a arraigned as a petitioner.
Yes.
So this writ petition was filed 15%.
Yes, and subsequently,
So 9%. Subsequently,
my lord, subsequently many CAN applications were filed.
Then the court transport them as party respondent.
Yes. Subsequently, my lord, many CAN applications were also filed to be added filed by other employees who were who wanted to be added as a party
Honorable Justice Mantha.
in the subsequent writ petition. Now, my lord, that has also been dismissed. That was also not pressed because they did not have any right on the same
they were
issue.
given liberty.
No.
My lord, on the same issue, my lord, even I had pointed it.
Cause of action.
I had even
And advocate for the appellant. What is the cause of action? Your cause of action? 6%.
Let kindly considers one thing, Millet.
6% payer has not been rejected. You pass here, then give answer. The 6% payer seeking permission to exercise option has not been rejected. They never approach the authority. 9% approach. Their payer was rejected. They are challenging such rejection order. So why the 6% was never made any payer
I'll tell you, Lordship.
for exercise of
I'll tell you, Lordship.
participate in the
My lord, kindly consider.
Just 1 second. Justice Bhattacharjee, read the first paragraph. First line you read.
15% have jointly filed the writ petition challenging
Not a
the
fact. Actual writ petition was by 9%.
by 9%.
Remaining কত হলো 3 remaining 8% or 6%. Remaining 6% were transport
Respondent, my lord.
But his lordship proceeded on the basis that it has been filed jointly by 60.
My lord, I'm sorry, this has missed my My lord,
This line kindly
yes,
say.
but Justice Bhattacharya had, my lord, consciously, yeah, I was appearing in the writ petition, my lord, Mr. Bhattacharya had consciously, my lord, even asked me about this transposition, and my lord, that had also been clarified because there were other CAN applications also.
Was that paragraph where it is clarified
My lord,
in the impugned judgment?
Only petition number 3, 4, 5, 7 and 14 পাঁচজন হচ্ছে অপশন এক্সারসাইজ করেছিল 6 মাস আগে ডিটেল
On this particular
Please,
issue,
please,
okay,
wait,
okay,
wait.
please,
there is
please,
no
my lord, probably,
that particular portion of the order.
my lord, that I do not see a reflection herein. My lord,
No,
there is no reflection herein, but my lord, it had been pointed out. It had been pointed out, it had been, the court had sought for a
Madam,
clarification.
This in fact will, how will it
sailing on the
prejudice
same
you?
boat.
Because your argument is not at their instance the authorities did consider,
My lord,
but they have relinquished their right to get the benefit because they did not first come in the writ petition.
my lord,
Now seeing others, they are joined.
yes,
Now they were transposed. Good, bad, indifferent order was a transposed. Why transposition? Because it was a claim relating to pension. Now, after transposition, this fact was pointed out to the learned single judge, but the learned single judge treated it as a joint writ petition, though they were not the writ petitioners. They were transposed respondents. Now, this point which you are urging,
my lord,
that as regards exercise of option, they did not challenge the order of the managing
my
director,
lord,
which he passed upon being relegated to them.
yes.
These
My lord,
points
that,
you can always urge in the appeal. We can, even if at all we want to give them the benefit, this point you will address. We will record in our order without prejudice to your rights and contentions.
my lord,
Then at least then the matter can be heard. Otherwise, if you want to seriously contest it, then you file your
my lord, my
opposition.
bone of contention is only one, my lord, that
We
is that,
understood that they did not file the first writ petition.
yes, they did not file this first writ petition.
Who are those 6? Who are
sailing on the same boat.
cost title? Come to the cost title of
এই
memo
10
of
থেকে
Yes,
10
yes.
থেকে 19 15
whether they
সূর্যচন্দ্র
are 10 to 15.
হ্যাঁ
My lord,
Huh? Take it both
yes.
10 to 15.
I'll tell you, Lordship. Just once. Yes, my lord. 10 to 15.
then why in your memo after Nepal you are including Kuveli Jha? Kuveli is a wife of Sujchandra,
My lord.
and Radhasham was also not there.
No, Radhasham was all there, my lord.
Where is it? In the memo of the writ petition certified copy order, his name does not feature. Oh, proposed
Yes, my lord.
Radhesham Prajapati, 11.
Somewhere
Very
it is
good.
transposed করে
Yes, my lord. Radhesham was transport, my lord. Transport.
as meant করে দিয়ে ট্রান্সপোজ করতে পারবে না লিখতে করিনি
হ্যাঁ সেটাই তো করে।
কপি অর্ডার ক্লিয়ারটা দেখুন 12 থেকে 15 করে টেকনিক্যালিটা রিমুভ
You did not prefer any leave to
No.
appeal?
My lord, that is, my lord, can too, my
your
lord.
PR you have seen your PR is Gesia has been pleased to treat the explanation shown in paragraph at that satisfactory for removal
Because this
of the
was
defect. So we are
this
satisfied
was in
where
terms of the first my lord.
we respond.
No, no, page 11. আরেকটা করেছি।
No, no,
Can
First report by the my lord, stamp reporter, my lord.
supposed to be the respondent person.
Or may I, my lord, transpose, may your lordships give leave to me, my lord, to transpose them, these 6 persons, as my lord, respondents.
responsive এবং delivery. So They have no cause of
What
action.
was the defect pointed out on 18th January?
My lord, 18th January, the order. The 18th January order. হ্যাঁ ওটা দিয়েছি। But one defect was Millard.
The order does not find fault.
এটা তাহলে একটু deal করি।
হ্যাঁ।
Your observation. এখন তাহলে তো cost title ই change করতে হবে।
সুপচন্দ্র
cost title টাকে change করতে হবে।
কত দেখেন ওদের নামিয়ে দিয়ে ইয়ে করে।
Supchandra was Millard named in the Millard.
We do one thing.
My lord,
We altered their status
my lord.
and we add them as proposed respondents in the appeal. And we will be giving this Subchandra is there.
No,
Subchandra
Supchandra has passed away.
We shall substitute.
Supchandra has passed away. His wife has been included, Millard.
that was implemented at the time of filing of
The appeal. Millard.
Implemented.
হ্যাঁ।
Oh.
Yes, Millard. Supchandra's wife, Supchandra passed away.
Who are his heirs? Only wife.
Wife, son is there. Millard's son is major. That's why, since this pertains to Millard pensionary benefit, Millard, only wife is entitled, Millard.
That is your choice. We do not comment.
No, no, Millard.
আচ্ছা আপনি can 2 of 2000
সব আমার খাই
একটাও দেওয়া যায়। আপনি ঝামেলা করে দিবেন, সে interest আছে।
চলেন
Limitation টা তৈরি।
এটা শুনলেও তো ভালো।
হ্যাঁ।
কি বলেছে?
আমাদের অবস্থা এখন দেখুন কিছুটা আছে।
এটা সামনের প্লাগকে দিই
Yes.
রাতে রাখবো ও চলবে চালিয়ে যাও চালিয়ে
আরে বেশি খুব চালা কিছু
Last question, you'll also directed the school authority to take instruction regarding the CCL, my lord. 3 months baby, my lord.
Where is Mr. Bose?
And I appear on behalf of the school authority.
What?
এটা কি হলো? Well, I do not know how the writ petition was made maintainable. That point probably my learned
You
friend
know
did
the
not.
previous episode? You were not there. Somebody else appeared.
He is not, he's out of town, Mr. Vivek Roy. I am
No,
told.
Bose.
Vivek Bose, he's gone to Bihar, I understand.
No, we asked him that whether to take instruction, whether he said that she has not joined also.
From
Just hear what we said, then you will make your. We said that you speak with your headmistress, and we will allow her to. She will go at a particular time and date and join her services, and thereafter that period of leave, so that she starts getting the salary. This was what we asked. Now you make your service.
Actually, up to 6th of December 2024, he was on maternity leave. 7th, he was supposed to join. She was supposed to join. She did not join. She is a clerk, sole clerk that time, during the time when she enjoyed the maternity leave. Her husband is an assistant teacher in the same school. Now, my lord, she, on 9th of December, my lord, the date is very significant. 9th of December, he applied for childcare leave.
She joined and applied.
9th of December. And 10th December, filed writ petition. We did not, my lord, had any opportunity to consider his prayer even. Writ petition was made ready before filing, applied before the, my lord, 9th of December. 9th of December, you joined there, went to school, joined there, applied for childcare leave, and 10th you file a writ petition. I am to place it to the governing body, my lord, for the purpose of sanctioning the childcare leave.
But perhaps my learned senior is not aware. Before
Let
that,
him finish off.
before that I applied, my lord, also.
That was a first application when, my lord, she was enjoying the maternity leave.
So why didn't you say that to Justice Sengupta?
Well, I find that affidavit opposition that was filed before the learned trial judge, my lord, was suffering from various, my lord, infirmities. Actually, that was not, many facts were not disclosed. But we are not, my lord, against him, against her. She is enjoying the. But we have arranged for a separate room for the child to be taken care because we have no clerk. We had no clerk up to 2nd of December 2024. A new clerk has joined only. We, the teachers, my lord, had discharged the work of a clerk. She knows it. She is absent for 6 months. Thereafter, till now, my lord, she is not joining. I have not, my lord, registered her from joining. There is no case made out. We have not registered her for joining. It is her school. Her husband is working. Her husband is working as a teacher in the same state school. We have arranged for her, my lord, because we want her. Because various, my lord, types of works, my lord, are pending. What a clerical job. The teachers are doing it. Teachers are carrying the books and papers. My lord, teachers are going to the DI office, my lord, for deposit of the office documents. My lord, higher secondary form fill-up process is going on. That also she was absent. No clerk was there. A new clerk but had no knowledge about the parameters of the work to be discharged by it in a school. Madhyamik Parikha Center, my lord, has been fixed in this school. Various clerical jobs are there, my lord.
What did you do after this order of 20th December? 20th December, after the order was passed, what did you do?
My lord's order was of 5th of
Not
March.
Lord's order.
No, no.
Page
Earlier.
87, page 87 of the stay application. Application for appropriate, 87.
Yes.
Come to the internal page 3 of the order.
That's the Joy Sengupta's order. Internal page 3.
The last paragraph.
In the exigent circumstance that the petitioner has to take care of 3-month-old child, and she believes that she is in dire need of CCL for such purpose, and there is sufficient days of CCL left in respect of the service of the petitioner, shall be at liberty to make an application for CCL up to period of 60 days within 23rd December, the same shall be considered. We have given her initially 21 days CCL.
Next page, next to line.
It is expected that the school authority will consider the granting of up to 60 days to the petitioner favorably. As a further interim measure, the school authority shall provide for a room for all female employees, including the petitioner, where such employees can take care of their child, including for the purpose of nursing. The matter will appear. This part has been fully complied with. We have given the room, my lord, for accommodation of the petitioner's child. Separate room, separate.
No, we are not on that, Mr. Bhattacharya. Court says it is expected school will grant 60 days.
We have given initially 21 days. We could have given.
আবার কথাটা শুনছে না। Whatever you have done previously, we are not.
No, on the basis of this application.
Yes.
On the basis of this prayer.
Order. On the basis of this order of 20th.
Yes,
December.
on the basis of this order, my lord, we have given 21 days leave. Sanction.
Let us see that page is at page
105.
You have given leave from 24th December, you went from 27 December to 16 January.
It is a 20th December order. Therefore, on 27th December.
105.
Yes, my lord.
105.
Yes.
So, pursuant to this order, she made an application on 23rd December. That is page 72.
My lord.
No, no.
Yes, this is the application 24th December 20.
So, as per court's order, she applied on 23rd. And court said that it is expected you consider him for 60 days. But you passed an order, page 105, saying that we are granting him till 16 January. That is how many days?
21 days. 21 days.
21 days. And when was your salary stopped?
From the month of February. Yes, my lord.
You have not been paid for the month of February.
Yes.
We are wanting to know, Mr. Bhattacharya, that when the court expressed a desire that you consider him for 60
The school
days,
would have been collapsed. Administration of the school would have been collapsed, but that has not been highlighted.
Stop that fact. Yet has directed 60 days. Don't think only this such and such TIC and secretary. He is also doing everything for education of our state.
this period is also over.
Yes, my lord. My lord, I will join. I will not, they will not allow me unless you.
I am not
Unless this order
objecting.
got directly,
I am record my submission.
Then even if we hold in your favor in terms of the order of Justice Sengupta, that 60-day period from 23rd December is over.
Already over.
So you have to join.
My lord, I will
Then
join.
you can make an application for further leave if you are entitled to, which
Yes.
they have a right to consider and either allow or dismiss.
Kindly observe that, my lord. I will join. My lord. Kindly observe that.
Then
Observe,
Mr.
I have no objection to
You
that.
allow, release his salary, and that period,
But salary release will be subject to the unauthorized absent period. But we have held certain period as unauthorized absent.
Which period you have held?
Period after the
After
is it a conduct of that employee that I throw a paper that I want leave and go away from the school without any sanction from the leave sanction? We have authority. We have been insulted that way.
No, Mr. Bhattacharya, what we are doing is that Justice Sengupta said consider him for 60 days.
60 over.
So that is what I am saying.
Yes, yes.
So that 60 days is over now.
Yes.
But your government has given 730 days in the
2
entire
years.
service.
2
term.
years.
Now we will say that up to 60 days in terms of Justice Sengupta's order, it will be deemed fit that if he is granted leave till 60 days.
I leave it to Lordship. Yes.
Now that period you regularize and so that she can start getting her
Yes,
salary.
yes.
And after joining, she will make a fresh application for leave. If so, if in accordance with law, and that will be considered.
My lord.
The entire writ petition can be disposed of. What is a
Today, writ is appearing for hearing before the learned trial judge. Today.
No, Mr. Bhattacharya, if you still, we can then make that subject to the writ petition again.
No,
That will
dispose of.
not serve any
Writ be
purpose.
disposed of. Writ be disposed of with this order, we all agree to this.
today date has been fixed.
Yes, today it is fixed. It has
No,
come.
not fixed.
No, it is in the monthly list.
2000 matter. As a hearing matter. This will never be taken up by
It will be taken up from 1987 and he has within 15 matters the matter is there.
Within 15 matters.
Yes. 980.
Under the heading
Bhattacharya,
hearing
wait,
list.
sir. Mr. Bhattacharya, we are not asking you to continue. On the earlier occasion, we were thinking that she will join and she can give given leave till this date. Today we are on how much? Today we are 10th of March. So we will not say that period is. We will say regularize it up to 60 days, which ends on such.
As your lordship. Yes,
and
yes.
we will dispose of the writ petition, which will entitle him to join and make further application.
And let him make a prayer
Present
according
it
to the area salary. We shall deal with the same.
সেটা বলে তো regularize the said period.
এই বেরিয়ে বলতে
22nd February it probably comes. ওদিকে 7 দিন। 22 তারিখ। 22 February, 22nd February.
Till the date of join.
28 দিনে February, 22nd February. 20th. কুড়ি তারিখ 20th April, 20th February.
এইটাকে সেটা সেটা সাইড করে যে 60 দিনের জন্য কি হলো এবং
When
February 20 it comes.
Only one thing, my lord, kindly page 52 once only, my lord. Page 52 of my application.
5th February.
22nd February, my lord.
20th February, not 22nd.
23 December থেকে 60 days, how much does it?
20th February.
20th February.
Yes.
Sure. Huh? Again calculate.
No, not she did not require. My junior is also efficient. He has calculated with the calendar.
No, then it comes to 28 days. 18 দিন।
28 has been 20th February. 28 has not come.
No,
You have not calculated it.
December.
December 31,
Right.
9 days.
December 31 days, that is
9 days, 9 days.
January 31 days. 40 days and 20 days. Yes.
20th.
20, yeah, February
Only
20th.
one occasion I am correct.
2 times. That will be adjust.
So you are engaging juniors who are doctors in mathematics.
Yeah, but nowadays it is required.
Well, page 52 once, well, kindly see.
আর কি হবে?
হ্যাঁ
Page 52 once.
We are not seeking it. Treating is an adversarial litigation. You go join. There is a need of childcare leave, but school interest is also to be given priority to some extent.
Certainly.
Yeah.
Certainly.
Though are receiving
page 52
education.
once,
He's
can you
wanting
see
the
there are-
attention of court
there
ballot.
is
This is not
amendment.
legible copy at all to me. I don't know, did it.
Mr. Bari, though are now getting education from this school, they are future of our country. You have to think it.
Well, page 52, well,
No,
the,
always the mother is to take the leave. Father could have
the
taken the leave.
benefit of child care
Paternity
leave,
leave has already, my lord, paternal leave has.
Try to
the
introduce
benefit of child care leave, well, may be granted
those who run the
till
administration,
120
they
days
know.
also. Well, that is the
As
rule.
you lord, as you lord.
Amended. Rules was amended, well, subsequently.
Are sir, we are saying, I
Madam.
told
Madam.
that you are entitled to 60 days.
Not as per law, I am entitled at
In
least
terms of-
120 days.
No,
In terms of the
that
court's order,
order,
court's order, I am 60 days.
it will expire on 20th February. We will ask you to join day after tomorrow.
My lord.
So they will regularize this head period by adjusting it with earned leave or whatever leave is contract till the date of your joining.
My lord.
yes.
And after that, you will join.
My lord.
Mr. Badi, you
I will
also
join,
have to, if you
I
tell
will
your
join.
client
I will
that
join
it is
day
a
after tomorrow.
battle ego, that
No, no,
all
no.
right, we will see.
No, no, man. As per your lordship
That
direction,
is-
I will join on day after tomorrow.
Maintain the academic child
I
is
will
born, we are appreciating that.
Certainly, my lord. I will join.
Others' requirement is there, but
Right.
that does not mean that you will sit and not make any alternative arrangement, because school is also there. They have to run the administration.
My lord, I will join.
If you have an otherwise feeling about your headmistress, how will you comfortably work in that institution?
Not
Tell us.
headmistress, a headmaster, my lord.
Headmaster.
My lord.
So this becomes ultimately the students suffer. So
Malad,
we are
petition has been
both
provided.
Malad, in this appeal, another issue was there. Malad, liberty may be granted to raise the issue by independent writ application, because earlier in 2023, Malad, I enjoyed leave CCL for my another child of dengue at the time of.
But dengue was
that,
over.
That sanction,
She,
that
after
was
doing
granted.
the
It
puja
was
vacation,
sanctioned.
suffered from
I
dengue.
enjoyed.
After
Subsequent-
puja vacation, when she was playing in the field, dengue leave was taken.
Subsequently, that
Applied.
leave,
We have found that dengue
Malad,
is no more there, therefore rejected.
by way of interpolation,
Don't, Malad.
that CCL has been converted into medical leave. I asked them to produce that document so that Malad, everything.
Therefore,
will be
that
discussed.
is
okay. Don't. I will give it.
No, Malad, there will be res judicata, Malad, unless Malad kindly grant
court cannot,
to agitate.
if it is res judicata, it is res judicata. I shall be
Settle
taking
that
that point of
settle that
constructive res judicata. You could have taken this point here also.
Both of you
That
are
is not your
requested to
prayer,
settle
Mr.
that.
No, no prayer.
I am prayer, Malad.
Come,
Yes, Malad.
your prayer, page 33.
Yes, Malad. Prayer A, Malad, kindly see. Lower portion. Rectify the services of the petitioner for the period of 21st November 23 to 8 November 23, treating those leave as child care leave in terms of the petitioner's prayer. Because they have, daily, behind my back, they have converted it into medical leave.
Well, then we have to use an affidavit to that. MC resolution or in support of my lord disallowing him the child care leave for that period. Therefore, the medical leave was taken.
No, no, prayer A, you are saying that is up to 1st April 25. Prayer A, page 33. What you have asked? Particular school to grant child care leave from 10 December 24 to 1st April 25.
Yes,
For
that
child,
was my
and
prayer.
direct the school to rectify the record of service book for the period from 21st to 8, treating those as child leave, child
Yes.
care leave.
That was allowed, sanctioned, I enjoyed. Subsequently, behind my back, they have how, kindly see, I have to copy that page.
Nothing like that, my lord. There is a
Kindly see
resolution.
how CCL has been converted into a medical leave. Kindly see behind my back. That was CCL and converted into medical leave behind my back.
Will you agitate? Actually, leave has been granted
Yes.
under the heading of medical leave. Will you agitate this point now again? That
Malat-
they should be treated as a.
For
2 years, nothing done.
In the circumstances, we are going to settle this dispute. At least we can give a liberty that we will be agitate this point.
My lord, that's why I'm praying. That's why I'm praying, Malsama. We may be granted to agitate this independently.
Keep this issue open for you to agitate in
My
another.
lord.
Yes, let him
agitate.
My lord.
But proper advice would be don't take
No, because the medical leave, I can.
since we are different angle, we are trying to settle that.
Very alert of his leave.
Matlab,
Without
medical leave can
7,
carry
8
forward,
months he is not
I'll-
coming to school.
Medical
School will
leave.
run by the booth. Who will run the school? Administration, no clerk.
They are
He
illegal.
has even no sympathy for the school
Matlab,
at all.
they will support the illegal
The
activities of the
teachers
head of
are
the institution.
carrying those papers to the DI office. He is sitting in house. My child has born. What happened before 2015 when this child care leave was not there? What happened? The
This
teachers did
child
not, the clerk did not work.
Kindly hear both of you with a view that matter will be settled, and after joining you will work
My lord.
diligently.
My lord.
We are going to settle
My
that the 60 days child care leave
My
will
lord.
be granted,
My lord.
and the rest period will be credited, will be adjusted with the leave lying in your account.
My lord.
Unless it is not unauthorized.
With an intention that henceforth the issue will be settled.
My lord.
Everything.
Are you
But-
serious about this? 21st November to 8 December? Leave that.
21st November to
Page 33, the period which they have converted to medical leave.
My lord.
Are you serious with that?
My lord,
We will dispose of the matter. We will dispose of the matter that has been adjusted against your medical leave. Accept that. Accept that. Similarly, because today 60 days child care leave will take you to 20th. So from
Very well, I will
21st
accept.
February to tomorrow, if you join 21st February to 11th March, that period also they will adjust along with the leave in your credit. Solve the problem.
I accept your lordship's proposal. My lord, if they in future if they do it again, my lord, in future if they do it again, same type of CCL into medical leave.
All right, let him
My
keep on
lord.
fighting against us.
My lord.
Make observation.
As a clerk, my lord, he is so audacity, the headmaster is running after her.
We are trying to
Mr. Bhattacharya, we have settled it.
That is their ego. That is their ego. A clerk is approaching
My lord,
the court against the headmaster. That is the ego.
Mr. Bari,
Recent
you
appeal
tell
has
your
been
client.
referred.
My lord.
Can order.
My lord.
Tell
Service book will be regularized.
Let her sign it. She is not signing it. 2021 onward service book incomplete. We cannot know, my lord.
She has not signed the.
No.
Perhaps she was not asked to sign it.
এখানে লেখো তো
That
ওই-
is why I am
আচ্ছা,
saying your lordship.
regularized by grant of CCL in the special circumstances করেছো তো?
That is exactly what for you need this cooperation.
It is further. চলো দেখে দাও। Yes, what is that?
Item 8.
For that, okay.
If you so desire, you can come back.
No, no. In reply,
We have another fixed matter.
Yes,
na?
I want
reply, may I file my reply, my lord, in this matter?
Reply to what?
Reply to the affidavit filed by the, my lord.
What happened, my lord, your
Opposition.
lordship, please to dispose of
That
my
yes,
appeal. I
আসো,
brought
the parties, let the affidavits exchanged by the
Applicant.
what problem not resolved?
they filed a recalling application, my lord.
And we have stated, my lord, certain facts, my lord, for which, my lord, the recalling is necessary.
Before that, they have to
No, that
satisfy your lordship.
No, my lord,
So you
about
are
the
not
limitation.
minded to proceed.
No, no, my lord, the fact remains is that, my lord, the certain facts, my lord, which has not brought to the notice of this court when the matter was taken up for consideration. The draft rules, my lord, has not yet been vetted to the, my lord, the minister and the other authorities. It has been said that draft rule has been settled. No, my lord, the draft rule has not yet settled, and the principal secretary, my lord, has proceeded on a wrong footings. This has been, everything has been categorically mentioned in my recalling application.
Principal secretary has proceeded on a wrong
Proceeded on the basis, my lord, the Archwell principal secretary, my lord, on a wrong basis, my lord, which he has not considered that aspect, my lord.
Before that, they have to cause
All
the
right,
hurdle
come
of
back on it.
they have to cause the hurdle of section 5 limitation.
Also reason
Number two.
yes, sir.
That's based on the
For the respondent. Well, left. I have come up against the order dated 22nd of March 2023. I come up against the order dated 22nd of March 2023, my lord. Passed by Justice Sengupta. तुम्हारे memorandum of appeal, my lord, will get. 3 points I took.
Stated, Mr. Nayak to produce something.
No, I think, my lord, your lordship's desire was. Yes, yes.
Has registered deed of partnership or anything like that.
No, your lordships had put 2 queries to my junior. One was whether this deed of partnership was registered or not. Yes, that we have documents to show it was a registered partnership. And secondly, whether my client was willing to pay the price of the property as on today, that we had expressed the client's indication of inability to pay today, because the allotment was made in 1995. This we had indicated on the last occasion. So they've also certain documents that were placed before the learned single judge, which were a part of my writ petition, that they had not disclosed, which I have disclosed now by way of my affidavit in opposition to the stay application.
I have filed my reply also. 3 points which we took was that there's yes, yes. Well, 22nd of March 2023.
No, memorandum of appeal.
Yes, no, the last annexed to the stay also, your lordship.
Well, it's the memo. Anything in memo. Jetai. Well, this is an application under Article 226. Yes, yes, all placed, everything was done. The grounds which have taken, 3 points I have. Number one, that there is a breach of the conditions of the agreement. Number one, we are in possession. Number two, and this hits the government exchequer. This was way of 1987, and now today is 2025. These were the 3 points. Lordship has noted it. Thereafter, they filed an opposition to my stay application. The conditions of the agreement, number one, we are in possession and government exchequer. But that was the 3 points only. Let Mr. Banerjee argue. These were the only 3 points. 5 or 4 times it has been argued on my behalf. But
Land was allotted in favor of one partnership.
yes, yes.
Partnership. Subsequently, some partners retired. Now they tried to make it a proprietorship company. Private company limited or anything. Yes, Mr. Man.
I'll just place my case.
Well, if anything is to be read in the between, I'll ask my junior. I'm not well, he'll read it out.
I can only do it for him. আমি করে দেবো। Lord, these two issues were also canvassed before the learned single judge. I'll just indicate, So first, the allotment is made in 1996. None of the grounds on which this impugned rejection has come about, which was assailed in the petition, pertains to the allotment conditions. There is no breach of allotment conditions at all. This other aspect with regard to retiring partners and all, that has also been settled by your lordship. By a judgment passed by my Lord Justice Bishwas, we had filed an application because they wanted us to come up with a document to show that one partner was retiring and how he would do it, and to make a publication or give a deed of retirement because it was amounting to reconstitution. That also had come about to be challenged by us before this honorable court. It was set aside. Both the conditions were set aside. We were sent back. Now, with regard to this land policy, this has also been settled. Yes, I'll just give a brief overview. I'll take your lordship through all the. So, with regard to land policy, this exact argument was made before your lordships. There's a division bench judgment of our honorable court that if the allotment precedes the land policy, then this land policy is merely administrative in nature. It can't have a retrospective operation. So just because there is a land policy by which the prices have gone up, that can't be a basis to deny somebody the allotment which was made prior to the land policy has come in vogue. The division bench judgment, we had relied upon this before the learned single judge, and that has been now been held in our favor. Two aspects I'll just indicate. Kindly have a look at page 57 is the letter of allotment. Page 57. My lordship will just. This was unpaginated, my lord. So if your lordship took.
How much stay opposition is 57?
No, application. No, my lord. Just bear with me for a minute. Please 57, my lord. It's a key. The can. This is very haphazardly paginated. Well, at page 75, your lordship will have a look at it. This is not. Bhool number. Page 75. I'm very sorry.
Running page 75.
Running page 75. That's right. No, this is the retirement of partnership.
1996
But I'll just place it. Allotment. This your lordship will see is dated 23rd of September 1996. 23rd September 1996. Of the stay application, yes. Well, this was the pagination will not probably match because ours also which is my notes also. Well, this was their document. I hope they paginated at least for your lordship.
Yes.
Then your lordship will have a look at page 75.
Well, our stay petition. Our stay petition.
So this is
page
এটা কিসের?
75.
The stay application page 75.
Yes, properly paginated.
I'm looking at the stay application, not can 2. Can 2. Page 75. Yes, I also have the same problem. Because what I have, this is what has been served upon us too. There's no pagination at all.
Now, whether in your affidavit in opposition, it's কি হবে?
I'll just check from my affidavit, not if it's there.
79.
Well, your lordship will look at our opposition, page 79. Yes, page 79 of our opposition, my lord. That is paginated. Your lordship will find that document.
And yes, I got
79.
79 from our affidavit.
My stay petition.
Can 2. Can 2. Page 75.
Allotment letter.
এটা আমার এখানে 79 তোমার ওখানে 75 ভুলভাল করে করা আছে 79 is the letter of allotment dated 23rd of September 1996. I am directed by order of the governor to say the we have filed a fresh opposition enclosing document. Just the writ petition along with all the documents that were there before the learned single judge, that is there. Yes. I filed a reply also.
Filed our reply also.
Page 79, your lordship will just have a look at. Yours is 75. Lord, my June. I have a stay application, page 79.
23rd September 1990.
In my brief it is 79, in my junior's brief it is 75. I think which is why there is a confusion.
Take your junior brief.
Your lordships have page 75.
Take your junior.
I'll take that and do that. Lord, may I just place the document? This is the letter of allotment in the name of the governor, so and so. Kindly have a look at clause number 343 onwards. Payment of at least 50% salami, that is 60,000, should be made within 90 days from the date of this letter, failing which the allotment shall be treated as cancelled. Unless the full amount is paid within 90 days from the date of issue of this allotment letter, interest will be charged at 7% per annum for the first 2 years and 10% per annum for the third year. On payment of the above mentioned amount of salami and balance salami, if any, actual. That's right.
For a modern design associate.
That's right. A partnership firm. Yes. Now your lordship will just turn over, my lord. If the amount of salami along with additional amount of account expense, if any, found on actual measurement other than dates interest so and so from the date of issue of this letter shall stand cancelled, and amount, if any, deposited shall be refunded after this term. So the only ground on which by this the letter of allotment could have been cancelled is my failure to make payment. Now I'll just show your lordships a couple of more documents. This is of 1995. It is undisputed that payments in terms of this allotment letter have been made. So the only ground on which they could have cancelled is that clause 6 that I just placed. Now, my lord, the authority writes a letter to me in 2005, which is at page 85. Agreement plan. This is what is there.
Only
This allotment is there, and then they start raking up different issues which get set aside by this court. But that is my partnership deed. That is my partnership deed. I mean, Malad, your lordship will now have a look at my affidavit in opposition once. No, from that I don't want to show anything else. Just have a look at page. I'll just show how the sequence has come about and how the authorities have just somehow tried to not give me this land. Because this, I'll go back and I'll rely on one decision of the Supreme Court, you know, that when allotment is made, here, page 85, your lordship will just have a look at. From my affidavit in opposition. Kindly mark this date, page 85 of the affidavit in opposition. And I'll show the impugned order also after this. This is 23rd February 2005. Now 1996 is allotment, payment made 10 years later, 2005. I am directed to say that it appears from a copy of an unregistered deed of partnership dated 17/3/1993 that 3 partners of the firm had since retired, whereas it appears from the true copy of the Register of Firms issued on 19/1/1996, kindly mark this note, that the firm had 5 partners, including the above 3. So the fact that this was registered with the Registrar of Firms and that document was with them is admitted in this line. Register of Firms issued on 19/1/1996 that the firm had 5 partners, including the above 3. In view of the above, I am directed to request you to submit relevant documents showing that the registration of the above 3 partners have been that the resignation of the above 3 partners have been in accordance with law, and a certificate of the Registrar of Firms is in relevant form regarding the undersigned partners. Kindly turns over to page 86. Is 12/7/2005. Registrar of Firms, I give them this document. This was a part of my writ petition. But this is issued by the Registrar of Firms on this date, showing that these were the name of the partners, these were the permanent addresses, and who has retired and who has come in. 5 partners, so who has retired and who has come in. So this is given from, because they want a Registrar of Firms valid document, this is issued by the Registrar of Firms immediately on 12th of July. Now this, culminates. Yes. That is. Your lordships will be aware that under the Partnership Act, there is no question of resignation. You either retire and you go, there is not a company. So I think they would have probably made a mistake here. But anyways, that document, I'll take your lordship a little further because this water has flown under the bridge. This culminates into page 94 of my affidavit in opposition. Now, this is 2005. Then next 2012, this issue is raked up again. Kindly have a look at page 94. So I keep writing a letter to him saying, please give me the allotted land. I've made the payment. Please allot me. And now 17th of October 2012 at page 94 is where 2 things are then taken up. With reference to your, may I, my lord? With reference to your letter, it is 16/7/2012. I am directed to request you to furnish following documents regarding retirement of 3 partners, copy of public notice published in the local newspaper regarding the retirement of outgoing partners, copy of deed of retirement of partnership executed and registered between the ongoing, that is the retired partners, and continuing partners. This matter will be processed further on receipt of your reply. So these 2 issues again they rake up. Now this is also completely foreign to the Partnership Act. There is no requirement of a deed. Reconstitution is not required. Then we challenge this. This gets taken up by my lord, by this honorable court, kindly turns to page number kindly come to the order, my lord. At 118, is the order challenging page 94. This is judgment of March 12th, 2013. Yes, yes. There is no dispute with regard to payment. Nobody's raked up that issue there.
Now your status, regarding status of the part.
Status also they don't ask. They actually ask things that are contrary to the Partnership Act, which is, kindly look at this order once. Well, the entire modus has been not to allot the land. I'll show it. Kindly have a look at page 118, 12th March 2013 order. The petitioners in this writ petition of the 226 dated February 26, 2013 are questioning a condition put by the Joint Secretary to the Government of West Bengal so-and-so by letter of October 12, 2012 written to the partners in the firm. The letter dated October 17, 2012 was written as regards, then it is quoted, I'm not troubling your lordship any further. A copy of the public notice given by the retiring partner was produced by the petitioners in response to the letter dated October 17, 2012. This document also we've disclosed. So everything that is at page 96, when they make this condition that make a paper publication, that is also done. That is at page 96 of the affidavit in opposition that your lordships are looking at. It's the second condition which I assail. A copy of the deed under which, please, may I just request your lordship to mark henceforth, a copy of the deed under which the firm was reconstituted was also produced. Even then, the authority did not take steps, presumably because the second condition mentioned in the letter dated October 17, 2012 was not complied with. Advocate for the state has submitted the document at page 61 shows in response to the letter dated October 17, 2012, the petitioners produced a copy of the public notice given by the retiring partner and stated their case regarding the second condition. It is not understood how the Joint Secretary writing the letter dated October 17, 2012 could ask the petitioners to produce a registered deed of retirement executed by the partners in the firm. The Joint Secretary did not mention which law required the petitioners to produce such a deed. Nothing in section 32 of the Indian Partnership Act 1932 requires the execution of a deed of retirement and its registration by the partners in the firm concerning the retirement of a partner therein. It is therefore evident that for no valid reason, the authority has kept the matter regarding which the letter was written pending. For these reasons, I dispose of writ petition, ignoring the second condition mentioned in the letter. The authority shall hear the petitioners within 4 weeks from the date of this order is served and give decision within 2 days from the date the hearing is concluded, no cause. So this condition of retiring, so I have made a public notice. I give the reconstituted deed. I produce it in court. The second condition is gone. Next comes, my lord. If your lordship looks at the impugned order which was assailed in the writ petition now.
121.
Your lordship will look at page 121 from my affidavit in opposition. Now, all this, they actually don't rake up anymore because they understand this issue is settled. The order makes a very...
Partnership, earlier partnership.
There is a deed of partnership which we've disclosed. That was a part of the writ petition also.
Now, whether any clause provision, what will happen in case of retirement of your partner?
No,
That clause must be there.
But now new people have come. No, partnership still exists. The part.
Show us that in case of retirement or death of any partner, what will happen?
Well, that
be there.
Well, that there is a reconstitution. The reconstituted deed was also placed before this honorable court. Sorry, Milan. I'm sorry, Milan.
First deed of partnership.
First deed of partnership.
There must be a clause that in case of retirement or death of any partner,
Yes, the lordship will have a look.
their share will be default upon their legal heirs automatically, or the partnership firm will be dissolved.
No, there is no dissolution of the firm. And even in 2013,
That clause, was that clause?
my lord, your lordship will have a look at the deed. We've disclosed the deed.
Well,
Yeah.
they say that has
Page-
been lost. They have
page
filed a general diary. I'll come up.
Kindly have a look at page 59.
Your opinion.
My affidavit in opposition. This is the deed of partnership of 1987. 1987.
Particular clause. In every partnership firm, there must be that.
Yes,
Case
yes.
of death or retirement.
Yes, yes. My lord, I'll just quickly look that. Lord, because of the judgment, I didn't look it up. I'll just quickly look it up. Give me 1 minute. My lord. The relevant part starts from page 63. My lord, if your lordship looks at 64, Mr. Naik is right. Clause 14 and 15. 14. 14 and 16. Wants to retire from the business, he may retire 2 months prior notice in writing, and something petitioner shall continue the business in the existing name. The money payable to the retirement partner shall be valid within 6 months from date of retirement, but without any interest, like any other partnership deed. And clause 16, on the death of any of the partners, the partnership shall not be dissolved.
Adopted.
Your lordship is looking at 16. Partnership. So partnership does not stand dissolved. Who are my partners? That reconstituted deed was also there. Kindly comes back to the impugned order, my lord, at 121, which was assailed before the learned single judge.
What prompted you to reconstitute the partnership?
No, that I wouldn't know.
Adopted.
No, that I wouldn't know, my lord. Why would?
It gives you so much power.
That I don't know, my lord. Why 2 partners wanted to retire out of 5 in 1995, and why there was a reconstitution? That must have been. In any event, your lordships have held that condition can't be imposed to deny me a land allotment. Now, kindly have a look at page 121. I'll try and satisfy your lordship that this was actually not a ground on which they rejected it. Kindly have a look at 121. Now, 2nd May 2013. This file is put up for passing orders arising out of so and so. This is just the 98 of my affidavit of opposition. No? Yes, no? Then there's a reconstitution, I would believe. This is retirement of partnership. 1993, these people are retiring. Well, this was, I don't know why this was there, but this was if your lordship remembers, this was also one of the conditions that I had to meet. So we made a deed of retirement and gave it. Asked for. And I'm told that it is already there, why we retired, but I don't want to trouble your lordship with that. The impugned order, the persons who retired, my lord, are my lord, Jagannath Sharma, Sita Bala Devi Sharma, and Kamala Karmakar. And they have given, I wouldn't know, my lord, but their letter is there. So all these documents, were there. All these documents the authority wanted.
They were there.
That why were you retiring from the firm? That also, that document is there. These 3 partners write to the partnership firms, you want to retire because of old age and new, but your lordships are right. I should have only checked that. The partnership form does not cease to be in existence. If the partnership form is there, I should have actually looked that up on my own. I'm very grateful. Now, kindly have a look at the impugned order which was assailed before the learned single judge at page 121. It's in existence. Partnership form is in existence. No, my lord, your lordship's query was that if I retire, then does the partnership form cease to be in existence? That we've shown from the clauses. This I should have also checked up. That is what I'm saying. That it is there. Now have a look at page 121, my lord, the impugned order that was there. The only ground please have a look at the 2nd paragraph. That's the case of the petitioner is they had been given an offer. Malaji Chakraborty has found it, no? Second paragraph, no? The case of the petitioner is that they had been given an offer of provisional allotment of land for a Kolkata plot in so-and-so for a sum of rupees 1,27,000, which was deposited in January 1998. However, they could not get the lease deed because they were asked to produce certain documents, ending with the last requirement in 17th October 2012. Wherein this, yes. Now, here they identify exactly what prevented them, because they identify 1 and 2. The learned advocate representing 2 is not required. Now, kindly have a look at the decision with reasons. It before the minor Justice Biswas's order, that order which was there, so it was not required anymore. That was also given, admitted, because your lordship seen in that order it was recorded. Now there is no other reason. Now kindly have a look at this reason that they give now. Decision with reason. It is true that a provisional allotment letter was issued in 1996. I find from the file that complications began to surface from 99 itself, when it was detected that the petitioners were considering a conversion of the partnership firm into a company contrary to the allotment letter. A formal letter was also issued by the Urban Development Department on 10/5/1999. Admittedly, the petitioners were partners in a partnership firm and they applied for the land accordingly, but as they had been considering for conversion of the business from partnership firm into a company, the entire matter remained contrary to the allotment letter. As a partner, as per law, had to bind himself legally, but it is not the case in regard to a company, which is a juristic person. Inevitably, all these required clarifications. Well, this is post Justice Biswas's order. Admitted position that I am a partner, partnership firm exists, I've given a notice. So he can't break up this issue, and he doesn't also. Thereafter, 2 partnership change issues took time. So he doesn't find fault with me. I find, now this is the operative part of the reasoning. I find that a very long time has elapsed from the date of provisional allotment till now. There is remoteness in the condition prevailing in 1996 and the ones that existing in now in 2013. There are gross and intrinsic differences vis-a-vis revenue matter of the government involving public interest. Division bench order. There was no land allotment policy for Salt Lake at that time, and prayers of many people for allotment of plots were considered quite liberally in 1990s. The land premium was very low. In this case, the premium that was charged was rupees 30,000 per katha, while the prevailing market rate assessed by the sub-registrar of Bidhannagar is presently to the tune of 50 lakh per katha. The government is required to work for public interest. In this case, there is a remoteness of 17 years, and admittedly, the allotment letter is nothing but a provisional one. In any case, mere issue of provisional allotment letter does not confer any right to property on the petitioners. Provisional allotment is nothing but a mere offer, and it cannot operate as a lease. The possession of the plot has never been made over to the petitioner. Interest in land can neither be conveyed nor be transferred except by registered deed. The land continues to belong to the state government. There is a land allotment policy notified by the government of West Bengal on 26 December 2012, which clearly lays down the manner in which the government land can be disposed of by following a transparent policy. The petitioner was not selected through an auction or transparent method like lottery, etc., but would stand to gain largesse of about 2 crores or so, and the government would lose the opportunity to earn a similar revenue through auction. For all the reasons and for public interest, I dispose of the matter so and so. Land allotment policy, please mark this, my lord, as per the land allotment policy by notification dated 26/12/2012 of the state government in LR and LR department, this land cannot be allotted to petitioner. It is consequently cancelled. So 95 allotment, 96 allotment, 96 payment made, 1,28,000 paid in 1998. Absolutely no deviation of the allotment conditions. The solitary ground on which this has been rejected is the land allotment policy. But if I may just immediately take your lordship to one division bench judgment of this honorable court, identical issue had come up where there was an allotment preceding the 2012 policy. And well, this your lordship will find from page 121 itself. Yes, this impugned order records it. Third line of the second paragraph. A sum of rupees 1,27,000 was deposited in January 1998. So that 50% what was to be paid, I paid on time, and then this was paid on the remaining on January 19. No, I have paid the entire money. This was what the entire amount was. This was what the entire amount that was there. Well, let us have a look at the allotment letter one. Page 79 of the affidavit in opposition. Yes, Manoj. 2. Serial number, paragraph number 2. Yes. The sum total of salami payable for the aforementioned so and so. And then I think there must have been some interest which they would have. But it has been nobody's case that payment has not been made in terms of the allotment letter. This one thing your lordship will not find. But I am not sure. I have paid 7,000 more via bona fide. No, sir, that I would have taken it.
Confirmation of 81, they confirm
And-
that I've made the payment.
And this
Relevant question.
confirmation, my lord, this confirmation is also there that I paid within time and everything is paid, is at page 81. If your lordship turns over, my lord,
82 last line. They calculate.
the entire calculation is made. And if your lordship looks at page 82 once, kindly have a look at page 82 of the affidavit in opposition. That first, there's only one paragraph then. The allottee has since paid all types of payment. Now, regarding execution of the lease deed, may kindly be taken up with 2 copies of site plan we made over also as enclosed. So the makeover, 2 copies of site plan, everything paid. Now they rake up different issues and come up only on the ground because now they can't take this point of partnership anymore. Because this order is passed of 2013. My Lord Justice Bishas's court, we produced the deed of retirement, partnership, public notice, everything. 2013, they take up this point of land allotment policy has now come in. So yours is not in tune with the policy, 2012 policy, we will not apply. That's the only ground. Now, if your lordships allow me to just, same issue had come up and the government had said, single judge will not held on the basis of this division bench judgment. Yes, will not, I'll show them. But impugned, your lordship will have to take the trouble of coming back to the order once. Yes, will not memo or stay, whichever.
Page 142. Yeah.
Paragraph 7 onwards, if your lordship kindly has a look at. The petitioners, I'm sorry, paragraph 7, yes. The petitioners admittedly paid the entire consideration for the lease that was supposed to be executed with the respondent authorities. The money that the petitioners parted with in 1996 cannot be valued simply by looking at the said sum at the present date. More importantly, this is the bit, a subsequent change in government policy cannot unsettle the valuable rights of others like allotment of a lease of land after obtaining full consideration for the same. In an unreported decision of Durgapur Development Authority versus Khea Abasan Samabay Somiti, pronounced on 16/4/2019, an honorable division bench of this court inter alia held as under, we are in agreement with the observation made by the learned single judge that since the land was allotted to the petitioner on February 28, 2011, the land policy of Government of West Bengal issued in the form of administrative direction on December 26, 2012 cannot have any bearing on the allotment of land made more than 1.5 years back. The administrative direction affecting the rights of the individuals cannot have any retrospective effect, and as such, the policy of the Government of West Bengal issued in the form of an administrative direction on December 26, 2012 cannot be taken into consideration by the Urban Development Department, Government of West Bengal for cancellation of allotment of land on February 26, 2011, particularly when the petitioner deposited the entire premium on May 10, 2011. Please have a look at the proximity here. 2011, 2012 codes in countenance. Here, 96, 98. and then they don't allot and they rely on the 2012 in view. And this is, if your lordships permit me, just to, because the finding in the division bench judgment is little more elaborate, because question of state largesse, amount increasing, that was also considered by the division bench.
But they have annexed it in the stay application, page 70.
Well, kindly have a look at stay application, page 71. They've annexed this judgment. ঠিক তো আমার তো মিলছে না কি মানে একটাও পেজ মিলছে না কেন বলতো 71 of সমবায় 71 of their stay application. আনুনি এটা এতবার করে বলেছিলাম no my lord, I asked them to get it better copy. Akanksha, I understand what is troubling the court. Lord, lordship will consider 1996 1,28,000. But that money today I was no, of course, no. I'm sorry, your lordships have also held that. My lord, but there are two aspects to this. One is the what are the can I be honest with this court? Well, the clients are no. Well, I'll just deviate. I was 3 months in the profession. I was appearing before my Lord Justice Vishwanath Shamadar. He was sitting in courtroom number 23. Condition of this client is such. 2 of my chamber juniors and me, we know him through a different source, so we're doing the matter. 3 of us are finding it difficult to get our everyday fees also. So I could not have. That is the partnership firm. But the only thing is, when I was. No, that if I'm in breach of the allotment policy, that they can come up with. The only ground on which, they have kept me hanging from night. There has been no default on my part.
Specific performance of contract, like that subsequent of value of land
Is we are ground. Correct. Down. Yes.
But that since it is an equitable jurisdiction, taking note that the court can exercise its equitable
100%. My lord, your lordships can, but
justice balance the
yes, my lord, this equitable, without a doubt, but this equitable consideration will flow from some legal basis. Your lordships have never countenanced equity dehorsed the law. Here to deny me an allotment, which is
note of subsequent development.
well, this subsequent development is well, this subsequent development, I understand. Well, this is something that we were also considering. Well, today, this money that I had 2 days back, I was watching one of these Facebook reels that come up. Your lordships also would have seen reels that come up. Well, somebody invested 1 lakh in a certain company in the US market in 1992. I'm not taking the name of the company. In one company or one blue chip company in the US market. That 1 lakh in 1992, 2025, its valuation is 60 crores. The company is gone, the money is gone. Which is why the learned single judge holds that how much I have paid can't be, today 1,28,000 is very less. Firstly, I've been denied the land. Secondly, I have put in 1,20,000, 1996, I was in class 8. I'm 43 years old today. That money also I have put in. I can't look at 1,23,000 when I'm 43 as opposed to when I was in class 8. There's a gulf of difference between the value of the money, and your lordships have always actually looked at the real-time value of money also. 1,96,000 is an astronomical figure. Yes, will not kindly have a look at this judgment. Well, this I understand. It's probably troubling the conscience of the court. This was something we were also debating upon. But the fact remains that this delay has happened for absolutely no fault of mine. They keep asking for documents which are irrelevant. Public notice of retirement. I don't know if your lordships have ever come across such a requirement. Under the Partnership Act, they have to put up a public, that also I have done. Every document they ask for, I give. Make payment, follow up. Then change of land policy, they deny it. Yes, Mulad, if I may just place this judgment, it's a shortest judgment, Mulad. Lordship will allow me to place page 72, third paragraph onwards. Upon fulfillment of all the terms and conditions, the ADDA by the communication dated January 28, February 2011 made a provisional allotment of 8.28 kathas of land in favor of the petitioner. Since the final allotment letter was not, I can't read this line, Mulad, forgive me. Yes, your lordships had noticed, I'm very grateful. Your lordships have noticed the last paragraph of page 72, where they say land allotment policy has come, and so identical to this. There cannot be any doubt that the provisional allotment is subject to decision by the Urban Development Department. We have seen the composition of the board of Adda. The distinguished members have taken a unanimous decision to allot the land to the petitioner. On the basis of the prevailing land policy, there was no bar in allotment of land, plot of land by ADDA in favor of the writ petitioner. ADDA has admitted this fact. On the basis of the then land policy, the Urban Development Department also could not have refused allotment. In fact, there is a categorical statement by the writ petitioner that persons similarly situated were allotted land pursuant to the same and or similar resolution of ADDA. Well, if I may just stop here for a moment, I'm not unnecessarily raking this up, but this allotment, your lordships would also be aware that such allotments of land in Salt Lake in these blocks have actually happened. So similarly circumstanced people were given these allotments. A lot of people I know have been made this allotment by the authorities then. The writ petitioner has complied with all the requirements. The writ petitioner may not have an absolute right to get an allotment, but certainly has a right to have his case considered on the basis of the existing policy. On the face of the then prevailing land policy, the writ petitioner could not have been denied allotment. The appellant, simply by sitting tight over the matter, cannot deny the benefit of the land policy as applicable on the date of the application, and could not have denied the right of the petitioner to get an allotment on the basis of a subsequent land policy when the fact remains that the petitioner, on the basis of the representations of the appellant, has discharged all his obligations required under the then land policy. The letter of allotment of land dated 28 February 2011 does not contain any term and condition for cancellation of the allotment of land. In view of paragraph 2F of the terms and conditions, the authority can resume the leasehold land for violation of the terms and conditions of the lease deed. In the instant case, no lease deed has been executed by the concerned authority even after a lapse of more than 4 years after allotment of land and deposit of total amount of premium. On the contrary, the allotment of land was cancelled by the Urban Development Department, Government of West Bengal. The letter of provisional allotment was issued in favor of the petitioner on February 28, 2011, in accordance with the resolution of the board meeting of ADDA held on February 26, 2011, and the said authority waited till July 5, 2014 for modifying the decision taken in the board meeting of February 26, 2011. Even though no reasons have been assigned by the board members of ADDA for modifying the earlier decision of the board meeting held on so-and-so, the court can presume that the modification is done by the members of ADDA for implementation of the land policy of state government dated December 26, 2012. We are in agreement with the observation made by the learned single judge that since the land was allotted to the petitioner on February 28, 2011, the land policy of Government of West Bengal issued in the form of administrative direction on December 26, 2012 cannot have any bearing on the allotment of land made more than 1.5 years back. The administrative direction affecting the rights of individuals cannot have any retrospective effect. As such, the policy of the Government of West Bengal issued in the form of administrative direction on December 26, 2012 cannot be taken into consideration by the Urban Development Department, Government of West Bengal for cancellation of allotment of land on February 26, 2011, particularly when the petitioner deposited the entire land premium on so and so, and then there were direction submitted, have no objection with a grant of lease related to 999 years to 99 years. On the same terms and conditions, direction to issue a lease deed in favor of the petitioners. Well, I'll be praying for the similar relief because that is what has been granted by the learned single judge also in our favor. Well, with regard to this contract, no, well, with regard to this being a contract, and if I can hold the state to its bargain, your lordships have held in 2023 MP Power Management, that when the state enters into any kind of a contract with the party, the state has to adhere. And even in the contractual field, a party is entitled to come to court and have the doctrine of legitimate expectation and promissory estoppel apply to the contractual field apropos the government. This will not in aid of this, because today what that state cannot act arbitrarily. No, so I am. No, so Milord, I'm going a step behind. Milord, I am saying that when a state has entered into a contract with me, that's right. I'm entitled to come to court and invoke the doctrine of legitimate expectation, have the state adhere to that contract. And even in the contractual, Milord, I'll get the plot. No, 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 no. In terms of the amount that are there, look, this for once, I'll beseech your lordship to have a look at the terms. The fact that I have paid. Look, while I was addressing your lordship on this, Mr. Naik quickly looked up, looking at the inflation rate, 1.28 lakhs in 1998 is accounts for how much? It accounts for 1.3 crores today. So I have also, but that is on the basis of a land policy which doesn't apply to me.
Now it's more than that.
But so in 2013, an act of court can't prejudice anybody. I have come to court and I filed the writ petition. This is somebody who's standing before your lordship who's actually paid the money. He has not defaulted anything. The authority delays it. Today, I understand it might affect our conscience that I'm giving it, but I am strictly going by the contours of law here. That's something that is my entitlement. And your lordships have held that even in the division bench judgment, that sitting tight over the matter, they've actually sat on it. And no other point. I'm carrying Mohinder Singh Gill also. Letter of allotment. Well, the letter of allotment, your letter of allotment, page 82 that I showed, 1998 at page 82, your lordship recalls, 98. There was direction to immediately issue because I have paid the money. 98, there is a direction that you grant the lease. So 98 to 2013, they sit on it, despite their own, page 82 is their document. And they themselves rake up issues which are not countenanced in law, which is why I could not stand the scrutiny of your lordships. No, my lord, that way I'm confident that your lordships will not will not really direct payment of something which is.
Just চিন্তা করিস।
With that, sir. I'll speak to him. I'll speak to him. সেটা আমি কোর্টে কি করে বলি বলো? কে কাকে পয়সা খাইয়েছে সেটা
Discuss করছি।
some very strange instructions are coming from Mr. Naik regarding. I'll speak to him myself once. I'll speak to him myself once. And I'll see.
You are placing the judgment with judgment copy given.
Oh, that one which has been annexed.
No, not that.
Taken out 2 copies. Division bench judgment.
Oh, my lord, the division bench judgment, better copies I have, my lord.
ওই সোমেন সেন আর রবি কাপুরেরটা তো?
ফোন করেছিলেন
না,
আমার আর কিছু নেই। নাম দিয়েছে?
You also sat for 13 years.
18 years. 18 years.
I didn't.
They have, after 1998, they made first communication according to him in 2013. That's been 15 years. Both of you sat.
No, আমার চিঠি আছে তো।
হ্যাঁ 18
No, I have written letters to them to allot it to me. And every time different conditions have been put. That is there in the impugned order itself. But this, my lord, I'll speak to my client. Your lordships have proposed a figure.
Provisional allotment.
Yes. No, if your lordships are not with me, then there are ways that I'll speak to my client. I understand, my lord.
Agreement will be executed.
That's right.
In the specific terms and condition of the lease will be applicable upon both of
But consideration can't change. Consideration can't change. Well, consideration can't change, but I'll take instruction. My lord. I'll come back.
কবে?
trying to get enforce the contents of the provisional allotment.
My lord, I am trying to, my lord, simply put, I am trying to enforce the bargain based on which the state has taken money from me. The state has taken 1,28,000 from me in 1996 and 1998 on the condition they'll allot me the land and they'll grant the lease. With this gap of time, the state can't come and today say that no, I'm going to increase my prices. Let us see, your lordships are sitting in a contractual jurisdiction today. A contract is entered into. Price has escalated. There's a revision of price. The contract does not have a revision of price clause. In no court, your lordships have never allowed any party, including the state, to say prices have gone up, I will not honor the contract. This is what is happening here.
To my knowledge, no.
So this is real.
Well, in all matters, my lord, this code appeal. Yes. Well, they don't listen to anyone.
No, they are happy because they don't have to give it.
Well, I'm facing. 4 katas, 1,28,000. Yes. In fact, what has been quoted 2 crores for 4 katas, it is not. Well, they don't listen. I'm facing every day, every court, contempt every day.
Also because they know that if they don't give, then they won't give. আমি তাছাড়া কি মানে what else can I say today? But this is one of those matters where I'll still take instruction, my lord.
কবে রাখবি বল? রেকর্ডিংটা পাঠাও। যে বলো যদি চুপচাপ চায় তো লিখে দেবে। আমাদের কিন্তু দেবে। On what could be the value? What instruction?
Lord,
Just কবে রাখ?
Lord, could I come back day after tomorrow? Will your lordship keep it as to be mentioned? I'll just take this instruction and come back.
তোর তো প্রপোজাল ঠিকই আছে।
Lord, Lord, my concern is that the longer it goes, the tougher it gets for me. So if I could come back day after tomorrow at any time, Lord, and just indicate if I have an offer, if I can ask my client to make some payment. Otherwise, we more or less finished arguments, Lord.
Yes.
I'll
Argument finished.
there is so yes, my lord.
For the petitioner for,
My lord, Mr. Dey is, my lord,
my lord, all the time, my lord, if it is,
he's engaged in court number 2, my lord. Kindly pass it over.
Yes, Your Lordship. Yes, Your Lordship. My lord, may I inform him? May I inform him? Yes. Yes, Your Lordship. Yes, Your State review, my lord.
My lord, that, yes, he was there that day because on the last occasion he didn't appear. Though he came in just in front of the court, but he left. That's why your lordship fixed today.
So we have to hear the review application first.
Yes, Your
My
Lordship.
lord, that I have to.
Yeah.
My
Yes,
lord,
Your Lordship.
what is the background? If your lordship allow me at least to
Here,
give a
contempt application, they have filed review.
my lord.
Review application, Your Lordship.
Who is your senior?
Mr. Chandicharan, Your Lordship.
What happened, my lord? In this case, the dispute is whether it is a retained land. My lord, this order is, my lord.
Yes. Yes, Your
My lord, they have, my lord, sought for a review of the order of the Honorable Division Bench of this Honorable Court, my lord. That is page in their review application 29.
What is the count?
Ground means the document which we have filed at the time of filing writ petition, another person who is my lord,
Discovery of new important matter or error?
no, not error, but discovery of new facts, because one document which was filed on our behalf, which was not even considered by the division bench, they, after dismissal of the SLP, they have filed a review application only to get rid from the contempt application. My lord, the impugned order, page 29 of the review application. We have heard Mr. Royal, learned advocate appearing for the petitioner, as well as Mr. Banerjee, learned advocate appearing for the state respondent in so and so. The learned advocate appearing for the state respondents produced the records before us, as we have directed earlier in our order dated 12/7/2006. Since there is some confusion in respect of the land in question in this matter, we have gone through the records because, my lord, court was, my lord, we have gone through the records, and it appears from the records that the subject plots of land being number 6174 under Khutian number so and so of Moja, Kalna district, Burdwan, have specifically stated that the said plot of lands were allowed to retain by the intermediary, and thereafter it also appears that the petitioners purchased the said plot of lands. Therefore, in our opinion, the learned tribunal proceeded in the matter, holding that the petitioners are post-vesting purchaser cannot be the correct position, since it appears from the records that the petitioners actually purchased the said plot of lands from the intermediary after the said land was retained by them. Accordingly, we do not find there is any question of vesting of the plots of land in question, and it appears to us that the learned tribunal passed the order on misconception of the facts placed before it. Hence, the order passed by so and so is set aside, and we direct the authority to record the name of the petitioners in their record of rights. My lord, My lord, they preferred an SLP. And my lord, the SLP was dismissed, my lord. Yes, my lord, I am submitting, my lord. My lord, 23rd August, my lord, division bench passed this order. On 3/1/2007, after January, 23rd August 2006, the impugned order, my lord. 6. Oh, this order. Mine. Then, my lord, on 3rd January 2007, SLP filed after 5 months. Filed? No, my lord, it was not admitted. It was listed on 19th February 2007 and SLP dismissed. SLP dismissed. Then, my lord, on 13th April 2007, according to them, they got the intimation of dismissal of SLP. Then on 17/4/2007, they sought legal opinion. And on 11/5/2007, legal opinion received. 2007. Then 29/5/2007, Xerox certified copy was applied. Xerox certified copy was applied. Then, my lord, on 14/6/2007.
My lord, in this matter, my lord, I want 1 week time. As because, my lord. Yes, my lord. Yes, my lord.
On 14/6/2007, my lord, review signed by LR. On 7/8/2007, papers submitted. And on 5/6/2007, it was received a certified copy, Xerox certified copy. Then 8/10, after 4 months, 8/10/2007, it was affirmed. Review application. My lord, thereafter, my lord, the contempt application was taken on so many dates. Your lordship was there because the incumbents were transferred. So it was directed to replace them. My lord, that was, my lord, state has, my lord, raised a point that it cannot be a merger since it was dismissed in limine. So they have taken in the review, but they have not checked before filing that under chapter 10 rule 2 of the appellate side rules, the review application is not in form and it is not acceptable at all by the court. My lord, exchange affidavits in all the matters.
As because, my lord, there are 3, 10, 11, and 12. My lord, 10 and 12 is, my lord, are perfectly right, my lord. But in 11, my lord, there is the person, my lord, died. My lord, my learned friend, my lord, person means the original petitioner. Yes, my lord, died, my lord. He filed, my lord, substitution petition for in the contempt application. Now, my lord,
Review application, no.
no, but now, my lord, now what's for I am praying 1 week time. I wrote a letter to my learned friend, my lord, before some days. give me the names of heirs and others, whatever may be the merits. And it is my duty, my lord. My lord, this is the letter. No. No, not only that, my lord. He wrote a letter to me, my lord, that in 2017, I was given the copy.
My lord,
And 2025, my lord, I also give you a copy. So,
my lord, 2.5 months back, at the request of Mr. Dey, I have xeroxed each and every copy,
my lord,
including
I am
the read
not,
application,
I am not
and
disputing.
given all the copies to him. Thereafter, the matter was heard. My application for substitution was allowed. He was aware, fully aware of the fact, and thereafter he didn't take any step. For substituting.
My lord,
for
in
substituting.
review, my lord, substitution.
In review, in a
Yes, my lord.
not contempt, my lord.
Contempt petition.
Yes. In the contempt of it.
Concluded.
Yes.
Complete.
Yes. My lord.
You mentioned that name?
My lord, all the papers which he give me, my lord, that was misplaced. Only for that is my lord.
2.5 months back, you asked me, give me all the copies. My lord.
You check the cost title, substitute amended cost title.
Yes, my lord. Only,
Note on
my lord, only that is my learned friend, my lord. We are advocate, my lord. Only I pray, give me that.
opponent.
No, my lord. Opponent at the time of, but he is my good friend, my lord. I may not want to.
Yeah, good friend.
Yes, my lord. Everybody, my lord, member of the Bar Association, all, yes, my lord, all the members of our Bar Association, my lord, all are good friends of mine, my lord, as because I, my lord, my lord, my lord, today, my lord, আরে দিয়ে দাও না একটা ইয়ে করে আমি করে দেবো
That's what substitution has been made in respect of contempt application.
Yes, my lord.
Same substitution be made in respect of
My lord.
one line.
That would,
my lord, that
make
was
everything
misplaced.
easier.
Only for that reason, my lord,
That would make everything easier. My lord,
Yes, my
need
lord.
not take any trouble.
Yes, my lord.
Nine legal hairs were substituted.
এটা দাও না ইয়েতে লিখে সাবস্টিটিউশন একটা কপি দিয়ে দাও
এই রে বাবা সেগুলো সব not to be taken any action করে ফাইল আলাদা করে রেখে
Only for that reason, my lord, I am ready to hear. But as because, my lord, I may not, if it is not possible for me to file
What is
substitution petition,
removing your
my lord, I have some difficulty as because all the files are not with me, my lord, misplaced only. Yes, my lord, on the next year, on the next Monday, my lord, I must finish this. This is a very simple, my lord. If your lordship will see the order, your lordship will astonished. My lord, that is on that day, my lord. On that day, my lord, I will submit before your lordship. Why your lordship will astonish on seeing the order, which is reviewed by us. Yes, my lord. Problem, total error. That is imaginary order. Yes, my lord, post-vesting, he never filed any, my lord, retention. In spite of that, my lord, that order was passed. That is a very...
My lord, the purpose of review, I am telling you,
imaginary order, that is.
My lord, a judgment and order of a civil court.
So, my lord,
and order of a
I
civil
only, my
court
lord,
was
pray.
filed of another person who is also owner of the plot. My lord, that time that document came to our hand and it was filed in the writ petition. So that was
Here, question is that the big riot retained the land.
my lord.
And hence there cannot be any question of vesting.
My lord.
Hence, it can never be stated to be a post-vesting purchase.
My lord, that is the order. What is? That is the issue. That they have not touched. They have not touched the issue.
The discovery of new and important fact.
No, my lord.
Had the document been there, that is.
Yes, my lord.
My lord, that is
My
not
lord,
the
first
case.
word is
What
on
I am
seeing-
saying,
on examining the documents.
my lord,
What document?
my lord, what I am saying, they have the reason for review that the judgment and order of civil court which was filed, that which was not taken cognizance by the honorable court, because honorable court considered our prayer only on the production of the records by the department, and their court found that it is a written land. Now they are taking the plea, since you have filed that document, they went up to appeal, thereafter the appeal dismissed, thereafter it was remanded to the court below, then up to that they have stated in their review petition, but thereafter they have not stated that it was again appealed.
Yes, my lord.
Lakshminarayan. Other one, yes.
Yes, my lord.
Motion 9.
That is 11, my lord. 11, my lord. My lord, that I given that Lakshminarayan, my lord. Yes, my lord, 661.
661.
Yes, my lord, I only for that is, my lord, I pray 1 week time, only for. My lord, your lordship can take the matter on. My lord, additional ground, Peter.
That I am for the state response.
But I have completed my argument. Not full. I'm like it. মনে হয় আমি বলতে পারবো না, আপনারা বলুন। আমি বলবো, আপনি থাকতে আমি বলবো, সেটা ওরা মারবে না। বলছি না।
My lord, the impugned order, my lord, passed by my lord Justice Soubhuto Bhattacharya, my lord, on 25th July 2022. Page, my lord, it starts from page 77, my lord, the main page from 80. It starts from 80. My lord, may I read? That present proceeding has been initiated based on letter dated 31st October 2018, issued by the Additional District Magistrate LR and District Land and Land Reforms Officer Malda, addressed to the Block Land and Land Reforms Officer Gajol Malda for recording requisitioned land of the petitioners in favor of Irrigation and Waterways Department, Government of West Bengal. Mr. Tulsidas Rai, learned advocate representing the three petitioners, being sons of late Konokulata Dasi, has submitted that the land in question was possessed and enjoyed by the petitioner till issuance of such memo dated 31st October 2018 for recording the land of the petitioners in favor of Irrigation and Waterways Department, Government of West Bengal. Contention on behalf of the petitioner that based on notice under section 3(1) of the West Bengal Land Acquisition Act 1948, herein after referred to as State Act 1948. A proceedings might have been initiated for requisitioning the land of the mother of the petitioner, but such proceeding was not concluded and no compensation award was paid in favor of the mother of the petitioners at the material point of time. Upon presenting the writ petition, it has been prayed by the petitioner for setting aside the acquisition of land measuring 0.57 acres of RS Dag number 16, LR Dag number 36, Moja Rangavita in Malda. Mr. Soumitra Bandyopadhyay, learned advocate representing the state respondent, has opposed such prayer of the petitioner based on the averments made in affidavit in opposition to the writ petition. Upon placing reliance on the relevant part of the affidavit in opposition, it has been submitted that the land of the mother of the petitioner was acquired in connection with LA case number 28 of 1976-77 for construction of stack yard in connection with Tista Barrage project, and possession was handed over to the requiring body on 21st August 1976. Based on such steps taken by the authorities, calculation sheet was prepared in connection with the said LA case by the Land Acquisition Department for payment of compensation award to the mother of the petitioner, namely late Konokulata Dashi. Ultimately, it has been submitted on 23rd August 1984. Award money was paid to the mother of the petitioners to the tune of such and such for acquiring of land of the petitioner mother, and in support of same, a document has been annexed to the affidavit in opposition, being Annexure R3. It has been submitted that 100% payment of compensation has been made as per relevant provision of the said Act 1948. Subsequently, based on letter dated 31st August 2018, issued by the Additional District Magistrate Land Reforms and District Land and Land Reforms Officer Malda, addressed to the Block Land and Land Reforms Officer Gajol Malda, relating to recording the name of the Irrigation and Water Department, Government of West Bengal, in the record of right based on the acquisition proceedings initiated by issuing notice under Section 3(1) of the 1976. Petitioners cannot have any right to agitate the issue afresh, as it has been done in the present writ petition. This court has heard the learned advocate representing the parties to the writ petition and perused the relevant materials available on record. It appears that one notice under Section 3(1) under the Act 1948 was issued in connection with the LA case number 28 of 1976-77 for acquiring the land of the mother of the petitioners. Upon placing reliance on particular document, which is Annexure R3 to the affidavit in opposition, used on behalf of the state respondents, it has been contended that award money such and such was paid to the mother of the petitioner on 23rd August 1984. And prior to that, possession of the land was handed over to the requiring body, that is Sub-Assistant Engineer Irrigation and Waterways Department, Government of West Bengal, on 21st August 1976. Since the entire proceeding under the relevant provision of the said Act 1948 was complete by handing over possession of land on 21st August 1976, and subsequently award money was paid to the petitioner 23rd August 1984, this court posed query to the learned advocate representing the petitioners as to why the writ petition was filed on 18 September 2019. This court does not receive any satisfactory answer on the delay made by the petitioners in approaching the court for quashing the acquisition proceeding, which has been initiated by the concerned respondent authorities in terms of the Act 1948. From the facts of the case, it appears that the requisition proceeding was initiated against the mother of the petitioners by issuing notice under Section 3(1) of the said Act on 12th August 1976. The petitioner's mother died 9th October 2000. My lord, it is incorrect statement, my lord. It is not correct. Although, my lord, therefore, it appears that the initiation of the proceedings of acquisition of state respondents, mother of the petitioner being the owner of the land in question, was alive for 24 years. My lord, I am again reading this. Therefore, it appears after initiation of the proceedings of acquisition of the state respondent, mother of the petitioners being owner of the land in question was alive for 24 years, but she did not raise any demur to the steps taken by the authorities in order to conclude such proceedings upon payment of award as well as handing over possession to the requiring body. As per appreciation of this court, it is the mother of the petitioner who was interested person in such acquisition proceeding who could have raised the issue which has been belatedly raised by the petitioners, being the sons of late Konokulata Dashi. Since the mother of the petitioners found that it is not required to initiate legal proceeding against such acquisition proceeding initiated by the respondent, which goes long away to show the authorities concluded the proceedings upon payment of award money to the mother of the petitioners. On analysis of the relevant facts, it appears that petitioners have tried to take advantage of the letter dated 31st October 2018, issued by the Additional District Magistrate, Land Resource and District Land and Land Resource Officer Malda, addressed to the Block Land and Land Resource Officer Gajol Malda, relating to recording name of Irrigation and Water Department, Government of West Bengal, in the record of rights in connection with the land in question. Such issuance of letter dated 31st October 2018 cannot confer any right upon the petitioner to raise the issue of acquisition or non-payment of compensation to the mother of the petitioner after 42 years of initiation of proceedings on issuing notice under section 311A of the Act 1948 on 12th August 1976. On the point of delay made by the petitioners in approaching court, reliance has been placed on Judgment Appeals Court reported in 2007-9 SCC 217 New Delhi Municipal Court Council, Bhatte Pan Singh and other, paragraph 17 and 18, and in Pan Singh Supra, the Appeals Court has succinctly decided upon placing reliance on mother judgment of the Appeals Court reported 2007-9 SCC 217 Bhatte Union of India thus. The reasonable time for approaching the court with the writ petition is 3 years. In view of the aforesaid discussion, this court does not find any merit in the writ petition and the same stand dismissed. However, the session and such. My lord, it is the case of the petitioners, my lord. The land acquisition case of the 1976-77, my lord. It was initiated with the name of the petitioner's mother, Konokolata Dashi Devi, who, my lord, died in the year 1992. That is not 2000, my lord.
That's been after 16 years.
My lord. That is, my lord, wrongly, my lord, they have stated in the writ petition. As such, my lord, it has been stated. But later on, I found, my lord, it is not correct. My lord, I'm... Wait. "30th April 1992, page 25, my lord, annexed P3 of the writ petition. Page 25. They have annexed, my lord, certificate from the office of the municipal councillors. Annexed P3 to the writ petition. And it has been, my lord, by affidavit they have filed. Certified that Konokolata Dasi is deceased wife of late Ram Narayan Bhuti, was resident of such and such, such and such, such and such. Malda expired on 30th April 1992. Left behind mentioned family, such and such. To the best of my knowledge, this is. But therefore, it is the date of the day, the 30th April 1992. What they have stated in the writ petition, they have, well, these, my lord, I am coming one by one, my lord. Let me place my one by one. This writ petition has been filed by their constituted attorney Gaurango Das by filing affidavits, stating himself as a constituted attorney of the petitioners, aged about 33 years. Writ petition affidavit, my lord, page 20. Gaurango Das, 33 years. But after 42 years of the land acquisition, 1977, 77, this writ petition has been filed by the 3 writ petitioners who are the sons and daughters of the 42, 76, 77 land acquired. And it was initiated with the name of the Konokolata Dasi, who was the original owner. I'm coming here. My lord, your lordship, kindly see that paragraph number, matter relates to page, paragraph I am placing from the writ petition. It is the case of the writ petition of what they have, my lord, stated in the writ petition, and now what they are implementing in the appeal stage, which is not permissible in law, my lord. In paragraph number 2, my lord, they have stated that The page 8 minute of the petition. The petitioner stated that Konoglata Dasi, mother of the petitioner, was the absolute owner of a plot of land, 2.65 acres of land, RS dag number 16, RS Khotiya number, LR dag number 36, RS Khotiya number 36, LR such and such. Thereafter, my lord, paragraph 3, petitioner stated the name of the mother of the petitioner was recorded in the PS LR Borgal record of right in the aforesaid plot. P1, my lord, is the record of right. They have annexed. That is page 23. Your lordship, kindly turn to page 23 of the writ petition. P1. অত্র সত্র দখলকারের নাম মিলন কনকলতা দাসী। স্বামী রামনারায়ণ দাস রায়ত। টোটাল ল্যান্ড মিলন 2.65, আউট অফ it দাগের অত্র সত্রের অংশের পরিমাণ 2.57. Therefore, my lord, he is the owner of the 2.57 acres of land, not 2.65. Plot number 36. And my lord, name of the petitioner, mother of the petitioner is my lord herein, Konoglata Dasi, Sami Ramnarayan Das, not Ramnarayan Bhuti. Not Ramnarayan Bhuti, my lord. This is the plot, my lord. My lord, and my lord, your lordship, then my lord, your lordship, he, plot number 36. I am coming, my lord, that is the RS plot. They have stated, my lord, in the paragraph. In paragraph 2, RS dag number 16, LR 36, paragraph number 2, writ petition. Page 23, my lord, that is the LR dag number 36. Khotiyan, my lord, 30. 30. 30. LR Khotiyan 30. It is correct, my lord. It is correct. And my lord, thereafter, after Jomi Sreni, Arkandar, that is the Arkandar, Sreni, Jomi Sreni, Arkandar. That is my lord, agricultural land. And my lord, Borgadar is there, Lalu Tudu. Therefore, my lord, they have stated in the other way, they are with the residential plots are there, they are residing there by constructing the house. This is not correct statement, my lord. Thereafter, my lord, paragraph 4, I am reading that the mother of the petitioner died intestate on 9th October 2000. But it is not correct. I have shown before your lordship. It is not correct. It will be, my lord, the 30th April 1990. Leaving behind her 3 sons, namely Prakash Narayan Bhuti, Vikas Kumar Bhuti, Milan Kumar Bhuti, and daughter, namely Chanda Sarkar. And the chairman of the English Bazar municipality issued certificate, but that I have shown before your lordship, page 25 of the petition, certificate. Thereafter, my lord, paragraph 8, your lordship, paragraph 8. That your petitioner stated that the petitioners and their brothers, namely Prakash Narayan Bhuti, made an application before the concerned block land and reference officer recording their names in respect of the plot of land. Since they became the absolute owners of the property, it is pertinent to note that out of measuring 2.65 acres of a little portion of land measuring 0.08 decimal was recorded in the name of one Madhav Chandra Rajabongsi. As such, subsequently measuring 2.57 acres of land has been recorded in the name of Konoglata. It is, my lord, correct as per the record of right. Therefore, Konoglata Dasi, my lord, was the owner of 2.57 acres of land, not 2.565 acres of land. Then, thereafter, my lord, paragraph 9, the petitioner stated that recently in the month of July 2009, when petitioner searched the recording in respect of the aforesaid land, it appears that the plot of land measuring 2.5 acres of land, plot number 36, Mouja Rangavita, jail number 84, Khatia number such and such. This has been recorded in the name of Irrigation and Water Department as Rayot, and your petitioners collected a copy. And right thereafter, petitioner went to the concerned department, wanted to know how the plot of land was recorded in the name of the Irrigation and Waterways Department. Then it was found additional district magistrate land and land reforms district and such and such sent a letter to the that recently in the month of July 2019, when a petitioner filed the recording in respect of aforesaid land, it appears that the aforesaid plot of land measuring 2.57 acres in the number such and such has been recorded in the name of Irrigation and Waterways Department Riot, and your petitioner collected a copy of the LR record of right. Thereafter, your petitioner went to the concerned department and wanted to know how the plot of land was recorded in the name of Irrigation and Waterways Department. Then it was found. Then the additional district magistrate such and such Malda sent a letter to the block and land reforms officer Gajol Malda Bhide state number such and such on 31st October 2018, wherein a sketch map was sent with a letter and directed him to record the said land in the name of the Irrigation and Waterways Department. Since the land was acquisitioned in connection with LA case number 28 of 1976-77 and receiving the sale land, later block and land reforms officer recorded the name of Irrigation and Waterways Department in place of name of mother of the petitioner, HON'BLE Rafi. Copy of the letter, my lord, that is page 26. For recording the names and along with sketch map. And my lord, pursuant to this, my lord, the record was it is recorded with the name of the petitioners, Water and Irrigation Department, page 29. Corrected record of right in the name of the instead of the Konokulata Dadi. 29. 29 people. Continuation. Nam CHO Jolosampad Daptor, Puriman 2.65, total area of land, Seni Arkanda, such and such. Therefore, my lord, that part in question is acquired by the state and it is recorded with the name of Irrigation and Waterways Department. My lord, from paragraph 9, it appears that recently in the 2009, when your petitioner search for recording, prior to that they have no knowledge whether this land has been acquired with the name of the petitioner's mother or not. And this, my lord, writ petition is filed by one Gaurango Das by affidavit constituted attorney stating this is my best of true to my knowledge. He is 33 years of old. My lord, then my lord, I am coming before your lordship. What is the power of attorney? My lord, my lord, your lordship, kindly turn to page 35. What is the power of attorney? My lord, Ram Mokhtar Nama. So having got document to show that award was passed. Yes, I'm showing everything. I'm showing before at the time of hearing before the another division by presiding my lord Justice Arijit Banerjee and Prosenjit বিশ্বাস. Sorry, my lord. Apurva Sinha Rai. Entire records have been submitted before his lordship, before their lordship. They have taken inspection of the record. It appears from my supplementary affidavit, paper book. Page 8, your lordship, supplementary affidavit. Page 8, supplementary affidavit. My lord, I'm reading, my lord. The additional page 18, order dated 17th February 2023. Supplementary affidavit. Yes. I'm showing before your lordship, my lord. Your lordship wants to know, my lord, from me whether a award has been passed or not. Award passed, and it was submitted before the Honorable Court. Supplementary, my lord, paper book. Page 8. I'm seeing, my lord. The additional land and land acquisition officer is present in court today. He has produced a copy of the relevant award. Hence, the contention of the appellants that no award was ever declared is not correct. But that is their submission, but they have said, but they have not received any compensation else. But it is the submission of Mr. Pan, my lord. Mr. Pan, learned advocate appearing to the says that his client never received any compensation. He has stated, my lord, in the it is also stated in the writ petition. But we have shown before their honorable court, my lord, that compensation amount has been paid and award has been declared. My lord, your lordship, name, my lord, what I'm showing before your lordship, the Ammoktarnama, in which capacity the constituted attorney Gauranga Das filed. My lord, your lordship, kindly turn to page 35 of the paper book. Page 35. It is not at all maintainable, my lord, before the honorable court. 35 of the paper book. First paper book. My lord, it is dated 18 June 2018, Ammoktarnama. Borabor Gauranga Das, Pita such and such. Another person, my lord, was given, Sri Nitya Mondol. Likhitam, Vikas Narayan Bhuti, Pita Surgiyo Ram Narayan Bhuti, Hindu such and such. Pasho Ammoktarnama Patro Midam Likhitam Kadjan Jage Nimo Taposil Burnito, Bhu Sampati, Amar Mata, my lord, kindly note it. Amar Mata, not our. It is, my lord, executed by only Vikas Narayan Bhuti. No other petitioners have, my lord, executed that power of attorney. Amar Mata Konoglata Dashi Mohashayar, Sotto Bogdokaliya Erar 30 নম্বর খতিয়ান মুক্ত সম্পত্তি হইতেছে। তিনি 16 আনা রকমে ভোগদখল করিলে 3 পুত্র 1 কন্যাকে ওয়ারিশ রাখিয়া গ্রহণ করিলে তাহার পবিত্র আমি পুত্র হিসেবে তত্ত্ব সম্পত্তি আমি পুত্র হিসেবে আমি ওয়ারিশ সূত্রে 1/4 অংশ মোতাবেক প্রাপ্ত হইয়া অদ্যাবধি। My lord, therefore, my lord, he has given, my lord, only, my lord, the Vikas Narayan Bhuti, not by the other respondent. But what he has stated in the writ petition, I am the Ammoktan and part of attorney of all the petitioners. And he has filed. In which capacity? My lord, that was not taken in the my lord, the writ petition when it was heard, it was not taken. My lord, let me finish my own way, my lord. He has submitted everything, my lord. Your lordship will not give me any chance. My lord, your lordship is so pleased. Oh, your lordship is so hurried. No, my lord, I have not. I have never prayed adjournment, my lord. This is the incorrect statement, my lord. No, my lord. Prior. Oh, সেদিন তো আমি আসিনি, আগের দিন আমি আসিনি, আগের দিন আসিনি। Prior to that, my lord, every time they have taken adjournment and it was dismissed on that one. I have never taken adjournment, my lord. Or once, my lord, I have, my lord, to check. Therefore, my lord, next date, my lord, I have, my lord, appeared before you. No, I'm gone, my lord, gone. What can be done? Well, it cannot be restored. It is correct, my lord. Now, my lord, I am, my lord, in difficulty. That should not be disclosed in the court, my lord. And now. Can I make one humble submission? Because you also heard a confidential resistance and special resistance matter. You also heard the matter. Mr. Mukherjee was appearing for the state. No, it is not written.
সব দেখাবো সব আছে আমাদের কোনো বুঝে নেই সব আছে
I will also for about. No, it is appearing at note 23. If the bench changes after new swearing, if the bench change, we are after swearing. Yes. My lord, then paragraph 10, my lord. Thereafter, they have collected the papers. Prior to that, they have no knowledge whether the land acquired. Paragraph 12. Today it will not complete, my lord. It will not complete. I am trying to my level base matter, whatever maybe. That paragraph. My lord, my lord, করে দিচ্ছেন, my lord করে দিচ্ছেন। কবে হবে? অমিত টাইম ফিক্স করবে, দুটো ফুটে এরকম করে সুবিধা। But 2 p.m. or 3 p.m. my lord, your lordship, any milord? Just a second, time to fix ball. Milord?
আমি একটা তুলেছি টাইম ফিক্স আমার 17 তারিখে আছে ফিক্স
বলি না my lord কে। My lord, it is. Milord, if possible, my lord, at 2 p.m. Milord, if possible, at 2 p.m.
ওকে
Till the date, my time, my lord, other my lord, we are my lord in the other court, my lord. Mr. Pan is my lord, everywhere is and my lord, we are. ঠিক আছে, my lord, যা বলবেন তাই হবে।